Wait, please, my lord. Sir, I beg to mention one matter for listing. Matter was last listed in the year 2023.
Admission.
Admission, my lord.
Give it to the court, master.
The date, my lord, sir. And the play also.
May it please your lordship, I would beg to mention item number 43. And I have entered appearance today on behalf of respondent number 2 in this case. And further, I will be filing my wakalatnama shortly. And I seek 2 weeks time to file my affidavit. in opposition.
Respond number?
Respondent number 2, Your Honor.
Okay.
And furthermore, there is an interim in play in favor of the petitioners, which I would like to bring to the notice of the
Okay,
court.
Mr.
N.R. Surana.
N.R. Surana. Learned counsel for the learned counsel has submitted that he has instruction to appear on behalf of the respondent number 2 in the case. So stop. And he will be filing the wakalatnama during the course of the day.
Your Honor, if possible, during the course of the day today
He
itself.
will be filing the wakalatnama on behalf of the respondent number 2 within 2 days from today. First of he has further sought. How much time you need?
2 weeks, Your Lordship.
2 weeks to file the counter affidavit on behalf of the respondent number 2. First up. Who is for the
I'm
petition?
for the petitioner.
Mr.
A Kabra.
A. Kabra, learned counsel for the petitioner, who is in attendance, has agreed to the prayer, state prayer of Mr. Surana. Post of Mr. Surana has further submitted that consent has been taken from the learned counsel for the learned standing counsel GMC to make the prayer. Post of the prayer made by Mr. Surana is accepted. Leads the case on so and so. After 2 weeks,
My lord, there is an interim.
the interim order passed earlier shall continue till the next date.
Yeah, please, Your Lordship. With the consent of the other side, I beg to mention item number 51, Lordship. Kindly allow us to withdraw this case, Lordship, to file a fresh, Lordship.
Mr. S.K. Saha, learned counsel for the petitioner, has submitted command instruction from the petitioners. Wants to withdraw the petition with the liberty to file a press. Mr. H. Borua, learned counsel on behalf of Mr. B. Ugui, learned standing counsel finance and taxation department from Assam, for all the respondents. Is present in view of the above submission made by Mr. Saha, learned counsel for the petitioner. The petition is withdrawn on dismissal with the liberty as paid for.
Deeply
My lord,
apologize.
there was an interim order operating.
The interim order passed earlier stands accordingly recorded.
Lordship, one more mention, Lordship, for item number 52, Lordship. In this case, what had happened, we are challenging the search and seizure, Lordship. And emanating from that search and seizure, final order has been passed, Lordship. So both the matter may be heard together. We are filing a writ petition, Lordship. Next week, Lordship.
Then how can this be continued? You have sought many adjournments here.
Lordship, both the matter may be heard together. Next week, Lordship.
On the prayer of Mr. S.K. Sahal and counsel for the petitioner is the case on next Wednesday.
Next Wednesday, holiday.
Holiday, Friday.
29.
You have informed the other side.
Yes.
Which is submitted, constantly.
I'm deeply obliged, Lordship.
May it please the Lordship. Lordship, I beg to mention item number 41. Lordship, I am appearing on behalf of Mr. S. Chetia, Standing Counsel of Income Tax.
Mr.
S. Chetia.
Yes.
Lordship, I am praying for 3 weeks' time to file affidavit in this matter, Lordship.
Which for the petitioner?
We have.
Mr. Ajedas, learned counsel for the petitioner is present. Miss
A. Pradhan.
A. Pradhan, on behalf of Mr. S. Setia, learned senior standing counsel,
Counsel of Income Tax.
Income Tax Department, for the respondents, as sought for and is granted. How much time you need?
3 weeks' time,
3
Lordship.
weeks time to file counter affidavit on behalf of the said respondents, or on behalf of the respondents. Full stop. List the case on friends. What is the interim order?
There's no coercive action to be taken.
The-
Pursuant to the
the,
assessment of.
Interim direction that was passed on which date?
So 51 to 51.
No problem. Just give us a minute. Twenty-eighth of April, man. 28th of April, 2020.
The interim direction made earlier on 28/4/2026. That no coercive steps shall be taken pursuant to the order dated 31/3/2026 stands extended to the next date of listing.
12/6.
Lordship, I have a similar prayer for.
My lords, small matter. I'm appearing from Bombay. My name is Nishit Gandhi.
Okay, Mr.
Nishit Gandhi. NM Gandhi.
M. Gandhi, Learned Counsel for the petition. And Mr. R.J. Das.
Much obliged.
Lordship, I have a similar prayer for item number 36 to 38. These are connected matters, Lordship.
Count 36 of the Liboham.
Here,
30
Lordship, I am appearing on behalf of Mr. S. Chetia, Standing Counsel of GST.
On behalf of Mr.
S. Chetia, Standing Counsel of GST, Senior Standing Counsel.
Who is for the petitioner? Mr. A. Kaushik, Learned Counsel for the petition is present. Ms. A. Pathan. Learned Counsel appearing on behalf of Mr. S. Chetia, Learned Senior Standing Counsel for GST. Has sought for further 3 years' time to file the affidavit in opposition on behalf of the CGST authorities. The prayer is allowed. The interim order passed earlier shall continue till the next date of listing. This is the case on. So
15/6.
same in 36, 37, 38.
36, 37, 38, Lordship. Highly obliged.
Highly obliged. May I appeal, Lordship? Lordship, prayer for listing, Lordship, for withdrawal. Tomorrow, Lordship? Yeah, okay.
May I please, Your Lordship, I beg to mention item number 11.
11.
Kindly, yeah. Kindly adjourn the matter for a week.
Earlier also you took time.
Just.
Hmm?
I
How much time?
have to,
What is the ground?
I have to take.
How many times you have sought adjournment at the motion station?
So I have
Once or twice? What is the ground? Okay, on the request of Mr. Z. Sophie, Learned Counsel for the petitioner, the case stands adjourned for the day. As it has been submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. At least the case on so and so. We'll find it.
May I please?
29/5.
Sir, beg to mention item number 35. Here I am for the response number 10, Lordship. Instructions are awaited, Lordship. I have taken the consent of other side, Lordship.
35.
2 weeks time you can give.
Mr. E.S. Locker, Learned Central Government Council, has submitted that the instructions are awaited and therefore the matter will be listed after 2 weeks. They submitted that consent has been taken from the Learned Counsel for the petitioner to make the prayer. The prayer is allowed, raise the case on so and so.
3rd June. 3/6.
I beg to mention prayer for listing, my lord. Motion matters for day after tomorrow, my lord. Similar matters are fixed on the same day.
Okay.
Deeply obliged.
Daily list for motion. Item 1.
Item 1, Lordships, I have already been communicated. A lot instruction not been received to them.
What is your allegation here?
My lords, my allegations against the officer in charge from the Sunapur police stations, my lords.
Hmm?
Against the officer in charge against the Sunapur police stations, the honors, who, my lords, in a civil disputes between two persons, the police calls asked to the police stations and forcefully the governor, my lord, the offense and undertaking from us that we are to vacate the plots of land within 15 days. My lords, this is a para 9 of my petitions, my lords.
What is your father's name in the Jamabandi?
My lords. Jamabundi, my lord. Bhuven Rahang.
Hmm?
Bhuven Rahang.
Huh? What is your father's name?
Babita Rahang. Bhuven Rahang.
No, paragraph 2. What does you? You said Konwala Rohang, Konmai Rohang.
my round the predecessor hour.
So as to from the,
From him, the Bhaven Rahang, and from Bhaven Rahang,
please explain, sir. Konwala Rohang. Where is that entry? Konwala Rohang? Konwala Rohang.
Page 22.
Where is Bhaven Rohang's entry?
Konbala Rahang, page 25. In Jamabandi.
20? 25.
25 page number, my lord.
Ushabala Rohang.
I,
Bhaven Rohang.
it had just of the vice 22/1/2011. Unmute Putta, Konbala Rahang or Lovat.
Bhaven Rohang.
Usarahan, Bhaven Rahang.
Ushabala Rohang.
Yes.
So there is another person, Ushabala Rohang.
Usabala Rahang, the relatives. Maybe.
No, how can you? Because this is by way of inheritance.
Inheritance.
Who is this Ushabala Rohang?
So they are
Because it is a joint joint name. Joint name.
Joint family property, my lords. Joint family property.
We have not explained. Uttaradhikari Sutre. Then what happened?
Then, my lords,
Now tell me, what was the share in the 117 Dagor, Duikotha Doslesa Konmai Kon Bala Rohangor Namjari Hoy. Thereafter, Hukum Usabala Rohang and Bhaven Rahang. Usabala is so out of initially Konbala Rahang had 2 katha,
10 less.
10 lesa. Right.
My lord.
After her death, by way of inheritance. Thereafter, what is Go? Page 22.
Yes, my lord.
Page 22, Go, remarks Go. Hundred 17. Done.
Lordship, kindly see the page 26.
Page 26.
Lordship,
Bhosawala Bhaven.
Lordship. After
One Namjari, then page 26.
date of Bhavan Rahang, Lordships.
That's Sobita Rahang, Utpal Rahang,
Utpal Rahang,
George
George
Rahang.
Rahang.
George, sir.
So how much land you had in the name of
My lords, the total land is there, my lord.
Bhaven Rahang? Please tell me. Please tell me.
One Kathat, one lesser.
Page 26. Page?
Page 26, Lordship.
Let us see
Next,
their name.
Lord.
Sobita Rahang. Sobita Rahang, Utpal Rahang, George Rahang. George Rahang. One katha,
One lesser.
how much?
One Katha, one lesser, I think.
One kata, one lesser has been sold.
No. First, what was the total land area of Bhaven Rahang? Please tell me.
Always runs one kata, 5 lesser perhaps, my lords.
Perhaps will not do here.
My lords,
Mr. Counsel,
my lord, I'm just.
don't go to perhaps. No use of perhaps before the court.
2 kata, 10 lesser.
No, after that, come to entry. Come to entry, page 25. Jha. Konbala Rahangor follow.
2 kata, 10.
Stholot. Sri
Ukharang.
Uttabala Rahang and Bhaven Rahang. Mata Konmai Rahang. So, Bhaven Rahang had a daughter and a son. Ushabala Rahang and Bhaven Rahang. Meaning thereby, by when of inheritance, maybe sharing the properties are divided. So, after that, how much was the land devolved upon Bhaven Rahang?
Usabala, she has expired, my lords, and the whole part without unmarried she, and her whole share has been got by the Bhavendraha.
If that is so,
My lord,
then it would be 2 katha 10 lesa.
2 kata, 10 lesser, exactly, my lord.
2 katha 10 lesa.
2 kata, 10 lesser.
2 katha 10 lesa means 1 katha 20, total 50 lesa. 50 lesa.
1 kata is
2 katha 10 lesa means 50 lesas. Now, come to entry, page 26, second entry. 117 আগৰ 1 কথা 1 লেচা মাটি খৰিদা দখল সূত্ৰে সবিতা ৰাহাং আৰু উৎপল ৰাহাঙৰ লগত গুণজিৎ দাসৰ নাম জাৰি কৰা হ'ল। Right?
yes, my lord.
Then, চক্ৰ বিষয়ৰ আপোচ বতৰা নাম্বাৰ so 117 নং দাগৰ 1 কথা 1 লেচা মাটি গুণজিৎ দাসৰ নামত নতুন new patta and new dag number has been made. And registration deed, value date, so and so. Registration, it is there. So you three were the successor in interest, you and your
Mother and
mother,
sister and
sister,
one other brother
and
is
so and
also
so.
there.
So out of 50 lesa, how much each one of will get? 25? 12.5 lesa. So Sobita Rahang and Utpal Rahang will get how much? 25 lesa. And they have entered into a sale deed, as it appears, with
Yes, my
the
lord,
respondent
they-
number 5. Respondent number 5. Now, what is the legal notice? Believing your representative to be carried, what is his case? Response number 5. One katha, one lesser. 117. Patta number 53. And Axonia plot of land 15 lesser. For the plot of land measuring one katha, one lesser, covered by that number. There was a registered deed and deed of sale of possessory right by Sobita Rahang. Registered it before registration, sub-register?
Registered it's the,
Sub-register?
registered is the
Sub-register?
sub-register.
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 Meaning thereby, there was presence of Sobita Rahang and your brother
Your brother.
in the office of the sub-register.
My lord, it's obvious.
Is it correct?
Is it? If they register.
What is
my
your
lord,
reply?
reply?
So, if it is fraudulent sale of deed,
Because they have challenged it, my lord. My lord.
have you filed any title suit?
And this
Have you filed any
No.
title suit?
till now we
No,
have.
I am asking you, yes
No.
or no?
Oh, we will file, my lord.
We will file.
My in the
Now,
meantime-
secondly,
Yes.
you are aware of the mutation order and partition order.
Complaint-
Have you filed any appeal?
My lord, complaint already filed, my lord.
Complaint where?
Concerned ADC office, my lord.
No complaint, no, it has to be appeal.
So we are against the cancellation of the debt.
Cancellation stuff for a desk that we have the file, my lord's the complaint.
Where?
Wait.
Is
just
it
right
mentioned
now-
here?
Right now, at the time of filing this petition, thereafter we have.
Because this undertaking may be a consent order. Why should we allow you to abuse the process of the court? If you know, do not show your bona fide that against the mutation order,
We have.
you have filed an appeal or application for cancellation.
Cancellations we have.
Secondly, regarding partition case, you have approached bona fide.
But-
Those are not there.
Later on, this has been filed, that's the,
I'm not understanding you. Please
after filing these writ petitions. And thereafter, we have taken the step.
file your affidavit.
After filing this.
Regarding what action you have taken regarding
Because.
the mutation order and partition,
Cancellation
partition
stuff,
order, what you have
already filed,
taken, and regarding the allegedly fraudulent sale deed, what you have directed. Don't try to
No,
use the process of rejurisdiction.
my lord, our issue is, my lord.
Please, you may be correct. Please tell the facts before the court.
Lords, the next that maybe we will furnish every details to my lords. That's the, we have approached before the concerned authority,
Otherwise, it will be,
my lords.
and otherwise also, it is if it is no action has been taken by the OC for registering the FIR, you have approached the,
No,
Commissioner of Police.
No, my
now
lord.
it is next course is to,
My lord.
no, next course is to go to the jurisdictional court. We tried to entertain you just to find out whether this undertaking is correct or not.
This is my lord.
Well, at that time, I don't know. But question is, how you have to approach. Writ petition is not the remedy otherwise.
Lords, the civil matter.
Not that, no, for that purpose, what offense, what cognizable offense the OC has done? Please tell me,
This-
which provision?
My lords, the,
IPC or BANS?
yes.
Which provision?
My lords, the police, the.
Tell me, recoursing to BNS, please tell me what offense?
Lords, if they, my lords, the fraudulently, you know, by.
No, firstly, an FIR can be lodged in case it discloses a cognizable cognizable. When
We
Mr.
have-
Sigdar, please state, I am asking few queries, you are
No, my lord.
answerable for that. Let us assume the undertaking was taken forcefully.
Forcefully.
What is the offense? There must be an offense, commission of an offense. Which offense? Which offense?
This is my lord's versions that threatening.
Which offense? There are more than 400 offenses mentioned in IPC or BNSS. Under which offense this offense will come?
Therefore, my lords, we have.
Please,
because
I am
before-
asking you.
Before your.
I am asking you, Mr. Sigdar,
They have violated my
what offense?
fundamental rights, my lords.
Fundamental right will come later on.
Lords.
You have lodged a complaint. Your allegation is that I have lodged a complaint before the officer in charge, alleging commission of an offense. He refused to entertain it. So you approach the higher authority, that is in the rank of superintendent of police, right? And that authority also has not taken any action. So tell me, what offense was committed? Don't jump to fundamental right first. What offense? Which offense? Of the IPC, now BNS. Please tell me. Then I will understand that it discloses commission of a cognizable offense. And an officer in charge must register it. As he has not registered it, so it gives you a right to approach the higher authority. If the higher authority does not entertain it, then it gives you right to approach the court, which is not the writ court, some other court. Please tell me.
This is
Because your sister and mother, they have registered a sale deed by going to the sub-registrar's office. That sale deed you have not made a part of the writ petition. Thereafter, mutation has been done. Partition has been done. And an undertaking is given by your mother, brother, and also you. Now you have come with an allegation that this has been done forcefully, undertaking. But what is regarding fraudulent sale deed? You have not instituted any title suit for declaration of the sale deed as fraudulent one. Neither you have challenged the mutation order, nor your mother and sister has challenged that partition order. New patta has been issued, new DAG number has been created, and because of that, he served as legal notice. Respondent number 5 has served you a legal notice instead of you serving a legal notice first. So what does it indicate, all these events? Why should I issue notice in this case?
my lords.
Just because you have lodged a complaint that was not entertained.
My lords, now that whether police can gives us kind
Please
of.
tell me your conduct.
On basis.
Who has, why your mother and brother has not been, they are not parties as petitioners if they are fraudulently cheated? Why they have not joined you? You are saying your mother and brother have been fraudulently cheated. A registered sale deed was executed by going to the sub-register office. Thereafter, Mutation order has been passed. They were mute. Thereafter, partition has been affected. They were mute. They remained silent. Thereafter, this thing, every land records have been corrected. They were served legal notice by the other person. Then you replied, simply denial. Then you decided that let us file a complaint. This undertaking may be a consensual one. Why all this machinery are to be used if you are not showing bona fide? Your mother and brother should be aggrieved. If the sale deed had been executed fraudulently, they went to the registrar office, registered the sale deed. There must be a permission, otherwise there cannot be any registered sale deed. Thereafter mutation, thereafter partition, new patta, new DAG number. Thereafter your mother and brother were holding over the land. He served a legal notice, not you. What does it indicate? And your family had more land than what has been sold. They sold 1 katha 1 lesa, that is their share.
My lords,
2 katha 10 lesa was the family property. And they have not joined you. And the lands are available to you. Out
No,
of,
my lords, after
despite
the-
sale of 1 katha 1 lesa to respondent of 5, still 1 katha, more than 1 katha is available to the family.
These portions fall under my portion, my lord.
Which portion?
This has been sold, my lords.
Which shall be, how can it be?
Sold. So, my lords, this is a civil dispute, my lords. It will go to the civil court, my lord.
You go to the civil court for declaring that sale deed as a fraudulent one.
My lord, this is
Go for appeal to cancel the mutation order, partition order, issuance of new patta, and
I will produce one week.
neither your mother nor your brother nor your sister have joined you, nor have been made respondents. If they had also cheated you, so what does it indicate? Is it an approach?
In this
Is it an
division-
approach by using this writ jurisdiction, you'd make some, sorry to say, blackmailing?
No, my lords, in this petition, my only the grievance is that
No grievance.
Police can
No, first you have to show your bona fide.
My lords, the 1 week time maybe given to
I'm
my
closing it, giving liberty with more. Neither the sale deed has been registered, has been challenged, nor the mutation order has been challenged, nor the partition has been challenged, nor new patta or new DAG number has been challenged. And the family has more than 2 katha and 10 lesas of land.
1 week time maybe given. So I will.
No, I cannot allow you to abuse this process of the court by
Let's
issuing notice, instructing Commissioner of Police to place all this.
My lords,
Go to the, if FIR has not been registered, then go under the provision
my
of
lord, I did
175.
not file any FIR, my lords. My lord, this is the we approach.
Which FIR?
We have not filed any FIR, my lords.
Good then. You sit over it then.
Against the undertaking, my lord. This is we have also a approach before the after filing this writ petitions. We approach before the concerned magistrate also, and concerned magistrate, Alaka magistrate, my lords, against the police officer and including
Yes.
whole the courts, my lords.
What is the petition? No, this statement is made after piercing question by the court. Let us see.
No, it did.
Magistrate has already held. Huh?
Then my lords,
This is suppression of total facts. When did you,
this petition after.
this order is passed by magistrate when?
After filing this,
This order is what? Show me the order.
no, this is the disposal. After filing this,
No.
the writ petitions, the
This petition was filed when? 23rd March 2026.
23rd March.
Then you sought,
then the court directed me to the.
no, 26/3/2026. The case was listed
Listed on 26.
and registry court directed to list the case after 4 weeks.
4 weeks. In the meantime,
Without making any objection.
my lords, the court verbally told me that you approach before the concerned magistrate. So in the next day, my lords,
So now the situation is that an order has already been passed. Is it not? On 27/3/2026. Am I correct? Am I correct?
this is order has been part.
Then why you have not disclosed this matter to the court?
My lords, we have.
When court was deliberating on your matter, when I asked the state council, as a result, state machinery is moved.
My lords,
Why you have not? It is for you now to challenge this order. Court has clearly held that I cannot treat this petition under section 175(3) BNSS as per the provisions of 173(4) BNSS has not been followed, as no FIR was filed by any complaint, nor any complaint was made in the concerned PS by the petitioner. No? Mr. Signer, this kind of approach is not appreciated. That suppression of facts.
no, my lords, that.
Heard Mr. Y. Sigdal, Learned Counsel for the petitioner. J. Henrik, Learned Junior Government Advocate, Assam, for the respondent number 1,
1, 3 to
3 and
7.
7, and Mr. A. Aforesaid, Learned Standing Counsel, Revenue Department, for the respondent number 2. Mr. Sigdal, I first observed in the 11 May order that projected facts and circumstances might be a case for approaching judicial magistrates. One under 173 read with 175. Then you remain silent, knowing fully well.
I tried to, my lords, I tried to express this, my lords, in the meantime,
But maybe I was
in the
not
meantime,
fortunate to understand your submission.
certified copy, my lords, obtained recently.
Certified copy, sir, decision order of 27/3/2026. We are in May. Your petition was last moved on 11/5.
11/5 petition.
Whole April month was there. Model conduct did not debar you to obtain a certified copy from the magistrate court. Para. The petitioner in this petition, Commander, petitioner projected that he is a successor in interest along with his mother, Sobita Rahang, his brother, Utpal Rahang, and his sister, Ruma Rahang, of
22 or 18 cents. More some of them are there. Second in police, second in jury. Second in jury.
Boben Raham. Full stop. A plot of land covered by measuring 2 katha, 10 lessons. Covered by tag number 117 and patta number 53. Located in village Tepesia, Moza Panbari, Konapur Revenue Circle, District Kamru Metro Subject Plot, was purchased by Konbala Rohang. Post of the said subject plot was mutated in favor of Konbala Rahang by a mutation order dated 12/7/1973. Full stop. After death of Konbala Rahang and alias Konmai Rahang, Commander subject plot devolved upon Ushabala Rahang and Bhoben Rahang by way of inheritance, and the names of Ushabala Rahang and Bhoben Rahang were mutated in connection with the subject plot by way of a mutation order dated 12/11/2011. Full stop. Subsequently, the subject land said to have been devolved upon Sobita Rahang, Utpal Rahang, and the petitioner. Full stop. Para, a registered sale deed. Full stop. Apart from Para, the projected case of the petition in this petition is that the purpose of the aforesaid facts are reflected in the copies of the records of right within bracket Jamabandi annexed to the petition as Annexer A. Full stop. Para, the case projected in this petition is that the family of the petitioner consisting of himself, his mother, his father, and sister had 2 plots of land, Roman 1 katha, 6 lessons at village Tepesia, covered by dag number 117 and patta number 53, under Moja Panbari, Cycle Gunapur, District Kamrup Metro, and 10 lessons within bracket Exodia Patta at village Tepesia, Moja Panbari, Sonapur Revenue Circle, Kamrup Metro. In this petition, the petitioner stated that the family was in possession, is in possession of a total plot of land measuring 1 katha 16 lesser at village Tepesia, Moja Panbari, Circle, Unapur Revenue Service, Kamro Metro, as indicated in the schedule in the petition and as mentioned here in above, full stop, para. Full stop, absolutely, the family is stated to be in occupation of the said plot of land measuring 1 katha 16 lesser by constructing residential houses and permanent structures. Para, an allegation has been made to the effect that the respondent number 5 had illegally executed a sale deed from the petitioner's mother, Sobita Rahan, and the petitioner's brother, Utpal Rahan, for a parcel of land measuring 1 katha 1 lassa, covered by diagram number 117 and pattern number 53, Moja Panbari, Circle, Sunapur Revenue Circle, Kamrup Metro. Post of para. The materials on record go to indicate that the sale deed was registered by registration number 2025 stroke IGR 015 stroke 1 stroke 2074 on 5/3/2025 before the office of the Hodor Registration Office, Kamrup Metro, post of. Thereafter, and against payment of consideration, post of. After registration of sale deed, Annexer A further go to indicate that after registration of the sale deed, the name of the respondent of 5 was mutated for an area of land measuring 1 katha 1 lassa in place of Sobita Rahang and Utpal Rahang by an order dated 13/6/2025 in mutation case number is 2606 MET stroke SON stroke 2024-2025 stroke 2025-003-0671 stroke OMUTC by the circle officer on the strength of the registered sale deed, post of, dated 5/3/2022, post of. Subsequently, on 21/8/2025, the circle officer by an order of given date in, what is the English name of Apos Botwara?
My lord,
Partition. Case number, case 27 of us. A separate periodic pata had been issued in favor of the respondent number
9.
Eight. My respondent is eight.
Okay, respondent number 8 over there. So what it? Respondent number 8. Full stop. Para. Another sale of possessory right in respect of the Axonia Patta land was also executed. Full stop. Para. It was the respondent number 8 on 20/02/2026 had served a legal notice upon the petitioner Sobita Rahan and George Rahan alleging that despite receipt of full consideration and repeated requests, they had denied physical possession of the purchased land, which amounted to breach of contract. Full stop. The sale legal notice was responded to by a reply dated 15/3/2026, denying the allegation and also the allegation regarding registration of the sale date and receipt of consideration of rupees 22,550,000 and rupees 1,68,000 from the respondent number 8. First of para. The petitioner in this writ petition has alleged that the respondent number 7 had called the petitioner, Sobita Rahan and George Rahan to the police station and on 17/3/2026 and in presence of the respondent number 8, had extracted an undertaking from all three of them that they would vacate the land within 15 days from 17/3/2026. It was thereafter a complaint was lodged. A complaint was sent to the Chief Minister, Assam, and to the respondent number 6, not 6, 4, on 18/3/2026 by the petitioner Sobita Rahan. Utpal Rahan and Ruma Rahan, alleging extraction of the undertaking under coercion by the respondent number 7 and sought necessary action after due inquiry. With such projection, the petitioner has presented the institutory petition. Seeking inter alia direction to the respondents, more particularly the respondent number 7 and the respondent number 8, as to why they shall not be restrained from illegal eviction and carrying out any construction over a scheduled plot of land by forcefully evicting the petitioner without due process of law. Full stop. Para. Though the petitioner has alleged that he and his mother and brother are co-sharers of a plot of land, co-sharers of plot of land measuring one kotha, one lesa, which was shown to be purchased illegally by the respondent number 8 by the registered sale deed number. I still remember. 2025 stroke IDR 015 stroke 2074 dated 5/3/2025. Neither the petitioner's mother nor the petitioner's brother has joined him in this petition, nor any of them have been named respondent in this petition. First of all, on a query, the learned counsel for the petitioner, it is stated that no suit has been instituted alleging that the said registered deed was illegal and fraudulently registered on 5/3/2025 by any of the family members of the petitioner. Full stop. Neither the order of neither the mutation order dated one 2023 passed by the circle officer, Unnapur Revenue Circle, nor the 13/6/2025, nor the order passed in partition case number 21/8/2025 passed by the circle officer, Sonapur Revenue Circle, has been challenged in any manner before the original authority or before before any appellate authority. First of all, on query, Mr. the counsel for the petitioner has submitted that when the petitioner approached the court of learned subdivisional judicial magistrate within bracket Khodor number 1 Kamrup within bracket Metro, Gauhati, by way of an application to direct the officer in charge, Unnapur Police Station, particularly under the provisions of section 175 4 read with section 173 4.5 BNS. Bharatian Nagorik Purokha Honita. The said application was registered and numbered as Miss within bracket general case number 05/2026. And after hearing the learned counsel for the parties, the court, the learned SDGM S, by an order dated 27/3/2026, declined to treat the application of the petitioner filed by the petitioner and petitioner under section 175(3) BNSS as the provisions of section 173 within bracket 4 BNSS was not followed, as no FIR was filed, nor any complaint was before the concerned police station by the petition. Full stop. By the order dated 2026, the learned SDJMS has held that the application was not maintainable, and accordingly the same was dismissed. Full stop. The said fact about dismissal of the application filed by the petitioner for particularly under section 175(3) BNSS has not been brought to the knowledge of the court on the earlier date of listing, that is 11/5/2026, when the court observed that in view of the projected facts and circumstances of the case, the petitioner, without approaching the jurisdictional magistrate under section 175 BNSS, paired with section 173 BNSS, had approached this court for raising doubt about the entertainability of the present writ petition. Full stop. In view of the dismissal of the application filed by the petitioner under section 175(3) BNSS by the order dated 27/2026, for the reason that the provisions of 173(4) BNSS was not followed, nor any FIR, nor any complaint was submitted before the concerned jurisdictional police station by the petitioner at any earlier point of time, this court is of the considered view that there is no material facts or no cause of action to proceed further with the petition. The petition is accordingly dismissed. You did not file the application by following proper procedure,
Oh, my lord,
nor any FIR was filed, nor any complaint was lodged. Court has recorded when this court had observed, you did not project the proper facts.
Well, the whole petition was then closed, my lord. The court formoto take cognizance, my lord.
Item number 2.
My lord. And that
Shall I more
no, my lord. Like
not appreciated? This kind of approach is not appreciated with suppression of facts. It is only after piercing questions for half an hour the true facts have come out.
Clearly, Lordship. Issue instructions.
So not
Yes.
received, Lordship, yes.
To
Whether
admit
the-
my application, Lordship, since 1 year is pending, Lordship.
Yes, Mr.
Lordship, not received, Lordship. We have communicated, Lordship. Lordship may direct the authorities to consider the application if it is
No,
registered.
this will not do. They will again sit, then Mr. Pathak will, Mr. Mohanto will come with a contempt petition.
Lordship.
Huh?
Lordship.
Then contempt petition, you will take about 6 weeks time, first, then 4 weeks time, then 3 weeks time, 2 weeks time. No, this is not done.
Lordship, then 1 week time may be given, Lordship.
As the last time.
Lordship.
Otherwise, he will appear personally.
Lordship.
The case has been registered. Who is that? Mr. Mohanto?
Page 32.
Page 32.
33, Lordship. Application was accepted. 33, Lordship.
Page number 30.
Also an application ID. Against which order?
Means the order he has not, only appeal.
Appeal has been filed against the mutation order at that, Lordship. The mutation case number NF.
Desire to file an appeal against the order, so currently had approached. Heard Mr. D. Mohanto, learned counsel for the petitioner, Mr. A. Aforesaid, learned standing counsel revenue department for response number 1, and Mr. S.S. learned junior government advocate Assam for the response number 2. Two. Mr. Roy has submitted that he has not received the necessary instruction in reference to the order dated 4/5/2026 passed by this court. First of, Mr. Roy has sought further 1 week time to obtain the necessary instruction in reference to the order dated 4/5/2026 as regards the appeal registered as application number 7 before the response number 2. First of, the prayer made by Mr. Roy is allowed. We is the case on next file.
2905.
It is observed that in the event the response number 2 does not provide the necessary instruction, the court may call for appearance. First, upon the response number 2.
Lodge. Obliged.
Item 3.
Petition is agreed with the order of the Police Accountability Commission. Lordship will have my initial complaint which I have filed before the commission. That is,
Mr. Ganguly, I have seen it now
Lordship.
after being listed for 3 days in the motion column.
My respectful submission is threefold. Basically, the 2 section, Lordship, section 81.
Firstly,
Lordship.
surface. I have seen your
Lordship.
sequence of events.
Lordship.
Right. If I go on saying, then your police accountability order,
Yes.
I don't find
Lordship.
any reason to disagree. Come to page 114 first. Let us
Yes.
read it.
Lordship. May I read, Lord? Yes. Complainant so-and-so has raised her grievances for the inaction of the police officials of Nagaon on the FIR she filed on 29/8/24 and 7/3/25.
Where are those FIRs?
That Lordship,
Page?
Lordship, 29/8 FIR is at page 68,
68.
and the other FIR 7/3/2025 is page 70.
Page?
70.
70. 70.
70.
Then the other e-complaint,
Lordship,
22/03/2025. Third line, another e-complaint,
yes, that was, that is at page 90.
90. Now let us see page 68.
Page
68.
First complaint.
60. It's 60, Lordship.
68?
60.
You registered, you lost it.
Yes.
Case has been registered.
Case
Yes.
registered, Lordship.
Case has been registered.
Yes.
Nagaon Police Station case number
Yes.
842. What has
Yes.
happened?
In that case, Lordship, final report has been submitted.
Where is that?
Final report, copy of the final report.
Okay. That is
not
final
there.
report.
Yes.
Final report.
FR has been submitted. And-
Final report. Okay.
And
What about 70/2025?
yes, page 70, that was preliminary inquiry was conducted, Lordship,
Ah.
as per section 173 of the BNSS, Lordship.
Ah.
And the allegation was found to be civil in nature.
Preliminary. Yes.
Allegation were found to be civil in nature, and the FIR
Ah.
was not registered, and it was.
So against final report,
Lordship.
you have many options.
Yes, those are.
Against closure of preliminary inquiry,
Lordship.
by holding that it is a case of civil nature, you have many other options.
Yes.
Right, remedy, judicial remedy.
Lordship.
Right, now what about the e-complaint?
E-complaint is lodged in the Assam Police Portal, Lordship.
That is regarding a DRT case and title suit.
Title suit, that is the
Who initiated the title suit?
title suit we initiated, Lordship.
For what?
For Lordship, the fraudulent activities committed by the revenue as well as the accused person who have been
So
included as
there
the-
was a DRT case.
There was a DRT.
There was an, meaning there was an original application by the bank,
Yes, Lordship.
right?
Lordship.
There was a judgment,
Yes, Lordship.
right?
Yes, Lordship.
So did you prefer any appeal?
That Lordship, that instruction I don't have at this
Hmm.
moment.
Thereafter, certificate proceeding had to be initiated, right? Thereafter, section 14 application is to be done.
Lordship.
Symbolic position, physical position had to be done. And that DRT order had attained finality.
Lordship.
So natural consequence is to take over your property which you had mortgaged
Lordship.
because of your failure to
Loan account
pay
become empty.
more than
Yes.
3 crores,
Yes.
right?
Lordship.
More than 3 crores,
Lordship.
which you had admittedly
Lordship.
taken by deposit of the title deeds
Lordship. In,
before the court,
in that,
before the bank.
in that respect also, another title suit has been filed, Lordship.
So what had happened? Any injunction order?
No.
No injunction order. No appeal against the DRT order.
Lordship.
So natural consequence is taking over,
Yes.
and I think it has been taken over.
Lordship.
Therefore, let us proceed. How the tried to forcefully occupy her property
Yes.
with the aid and assistance of police official. Now, police official has, okay, let us go. Inner complaint has referred to the ongoing dispute between her and RD Motors. RD Motors is the buyer after auction,
Yes.
right?
Yes.
Buyer after auction. If the auction process is invalid,
Lordship.
did you challenge? Have you challenged?
No.
No. A detailed report was called from SP as regards the status of FIR.
This is the problem, Lordship.
No, let us go.
Lordship.
Let us have this total.
Lordship. Lordship.
Let us have a forensic
Lordship.
examination of the order.
Lordship.
A detailed report has been submitted by SP. Please read that.
Yes, a detailed report was called for from the SP Nagaon as regards the status of the FIRs filed by the complainant and also the status of the other litigations pending between the parties by case number so and so and case number so and so along with necessary documents. A detailed report has been submitted by the SP Nagaon along with necessary documents which can be summarized as follows. The complainant so and so owned and possessed a plot of land measuring 3 kata 11 letters by Dag number 967 and Patta number 379. But now the said plot of land is not belongs to the complainant. The complainant borrowed a huge amount of loan from Canara Bank Nagaon and could not repay the loan and remained silent since 9/6/2018, which raised up to so and so.
3 crore 36,
Yes.
34 lakh.
Yes,
Hmm.
only in the year 2023. The matter was informed to Circle Officer Nagaon by the branch manager Canara Bank Nagaon. And as per provision of the bank, the said plot of land was e-auction and physically handed over the said plot of land to the purchaser, MS so-and-so Private Limited on 19/10/2023. The handing over of the property by the bank officials to the new purchaser, so-and-so, was done in the presence of Circle Officer ACS by observing all the formalities in presence of witnesses, and law and order was maintained by local police and provided security to the government officials. SP Nagaon has mentioned in his report that there was no any use of power, forgery, inaction by police as alleged. Relating to the incident, complainant Rupa Bora filed an FIR at Nagaon PS on so-and-so. A case was registered by Nagaon PS case number so-and-so under so-and-so against Messrs. RD Motors Private Limited, which was investigated by police, and after completion of investigation of the case, submitted in FIR as civil dispute by so-and-so dated 29/11/24. As regards FIR dated 7/3/25 filed by complainant, it is submitted that preliminary inquiry under the provisions of section 173(3) BNSS was initiated, and after inquiry, the matter was closed since the allegation was civil in nature. The complainant was informed accordingly. Another FIR was submitted by Dibojyoti Soikia on behalf of Messrs. So-and-so against Rupa Bora and others, which was registered as Nagaon PS case number so-and-so and investigated. During investigation, sufficient evidence could be collected against the FIR named accused person so-and-so and have been arrested in the case, and the case was submitted in CS by number so-and-so. The entire fact is based on loan taken by the complainant and non-payment of huge loan amount to Canara Bank, Nagaon branch. The e-auction sale of the said loan property belongs to Rupa Bora was done by Canara Bank Authority with the help of district magistrate and circle officer. The allegation leveled against the police officers of Nagaon PS and SP is totally false and concocted. The bank officials and the district administration have legally and rightfully e-auctioned the property and handed over to the legal purchasers. The commission examined the detailed report along with the documents annexed, which supported the fact that the property of the complainant owned a huge amount of loan to the Canara Bank, for which they communicated the matter with the circle officer for transferring the property of the complainant, which turned NPA on 7/11/2023. And the district magistrate also issued a necessary order for realizing the aforesaid debt of Srimati so-and-so, and thereafter the aforesaid land was auctioned by the bank, and bank issued sale certificate in favor of the successful bidder with the help of the district administration. The complainant has not disclosed the actual aspect of the matter, that the property has been rightfully auctioned by the government authority for non-payment of huge loan. Now, two proceedings still pending before the DRT and the civil court, so the petitioner can pursue her matter before the appropriate authority for redressal of her grievance. On the other hand, police report also reveals that preliminary inquiry was conducted on the FIRs filed by the complainant, and it was closed and ended in FR. The complaint itself is bad for suppression of material facts, and the commission has nothing to do in the matter. The petition accordingly stands closed and disposed of with a liberty to the complainant to approach the higher authority, Ombudsman RBI, for redressal if bank authority has violated the rules and procedure while conducting such auction. So far as regarding the filing of final report in the FIR filed by the complainant, same shall be raised before the court of law. Informed the secretary, so-and-so, NSP Nagaon, and the complainant.
Now, why this is bad?
Bad because the commission has relied on the report of the superintendent of police, lordship. He himself is an offending party in the case. I have made specific allegation in my complaint.
Show us
Look,
that there was no order of the district magistrate. After symbolic position,
lordship.
so it was not accompanied by any order of the district magistrate under section 14 of the Act, Surface Act. It is an admitted fact that the loan became NPA,
Lordship.
right? So after that, possession was taken pursuant to an order of the district magistrate, the SP has said, right? And if an order, that kind of order has been passed, then use of force is permissible. If there is resistance.
Not only use of force.
No, please.
Lordship.
So you have alleged all this, but show us that there is lack of no district or magistrate order. Court is not going to find out district magistrate order. Where is the averment that there is no order under section 14 from the district magistrate to take over the property with the help of circle officer and bank official and presence of force?
Yes.
Which date it was taken? On which date district magistrate has passed the order, meaning thereby district commissioner in the capacity of district magistrate, when he passed the order, or he did not pass an order at all. You show us that SP has said falsely in the report.
Simply denied by the SP.
No. You tell me, make a strong statement.
Lordship.
So that the district magistrate also issued necessary order for realizing the aforesaid date of say so-and-so, and thereafter the aforesaid land was auctioned by the bank and issued sale certificate. So the point is regarding taking over and forceful use. Right, that is an excess police action. Police action in excess.
Two FIRs
In
were
what
filed.
kind of?
Two FIRs were filed
No, let
on
us see.
our side, Lordship.
Let us see the
But
content. Let
interestingly,
us see the contents.
Lordship,
When it was taken over.
that,
Two FIRs, you have two options.
yes, that Lordship is there.
That is not a case for police accountability.
Lordship.
On taking over possession, there was order of the magistrate or not. Let us see section 14 of the SRPC Act. SPA is saying that there is a order of the district magistrate to take over the property. And bank normally does not proceed without an order of the designation. Even they wait for 2-3 years, I have seen. I have disposed of many petitions under section 14. Said they do not proceed otherwise for taking our position without an order of the magistrate. Now, section 14.
Lordship too.
Being 4, being 8. Cause to be taken and use or cause to be used such force as may, in his opinion, be necessary. Force is permissible.
Which is permissible. Lordship.
Permissible under the order.
But police officials were.
Yes, we'll pass the order at leisure because some cost is to be imposed here.
Lordship, not only this, I have another two. My basic contention is threefold. Basically, this complaint.
Let us see your prayers.
Yes.
Because it is self-contained
Lordship.
order
Lordship.
of the
There is
Assam
only
Police,
simple
Assam
enough
State
contrast
Police
and
Accountability
police.
Commission, self-contained orders, regions are there.
And my respectful submission is that
And
report from
prayer 1 and 2, A and B,
Lordship.
pertains to
Yeah, that Lordship.
order of the
that Lordship
Accountability
is there.
Commission.
That Lordship is there.
Prayer 3, unregistered FIR,
Unexplained.
you
That
have
also-
recourse.
Damage is there.
Prayer C,
My
prayer D,
Lordship.
this is not a case
Lordship.
which is required to be handled because of all the events earlier.
And section.
And what kind of disposal of representation after you approach the Accountability Commission? So we'll pass to later.
There is also a violation of section 81 and 88 of the.
All points are open for you.
Section 81 provides that I must be given a reasonable opportunity to show cause and to lead evidence, Lordship. If I may take your Lordship's attention to section 81 of the Assam
But
Police
if
Act.
views of the process, then it is not required.
Section 81,
All points are open for you to be asked. We will pass the order at later on some other day.
for a moment, Lordship.
On
Section-
other days, all points, I'll give you all the times. Because other cases are there in the list.
Section 88 also, the
I'm not very persuaded to issue notice. So you have to convince me. And get all the documents of all the proceedings
Yes,
of DRT, sales certificate, everything
yes.
with you.
I will
So
do-
that when I ask, you can put
I will-
it
I
there.
will do
Mr. Ganguly,
Yes.
A. Ganguly for the petitioner and SS Roy, State Council. Are heard, release the case again.
I'll have to get the copies.
Hearing that.
It come after 3 weeks then.
No.
I'll have to get
I will-
the copies.
My memory is very,
Let it be after 2 weeks then. I will have to get all the
1 week,
copies.
next week.
1 week will be
Otherwise,
difficult.
my memory, I
Let it
have
come
to
after 10 days.
refresh my memory.
Let it come after 10 days. then.
No, these petitioners are not showing good conduct. Next week.
We do
I
it
hear you.
after 10 days.
Video.
2nd June.
First and second, I will not be in Gauhati, Lordship. After 4th, any day, Lordship.
Fortune. But tell your client also, she might be visited with cost also.
4th June.
Yes, Ms. Bordole.
Yes, Your Lordship. I have received the instruction. We can apply, Your Lordship. Same,
Are-
we have given the written.
Mr. Das, SC Das, Learned Counsel for the petition, and Ms. Ann Bordole, Learned Standing Counsel, Revenue Department for the Respondent number 1 and 2, and Mr. Who is there? S.S. Roy, Learned Junior Government Advocate, Assam, Rajasthan number 3 and 4. Full stop. The petitioner has approached this court. It's a grievance that petitioner, being a landless person, has been in long continuous, peaceful and uninterrupted possession of a lot of land measuring 1 katha out of 4 kathas falling within DAG number 137 new stroke 100 old, situated revenue village, Bamunpara, part number 1, Moza Bilahipara Revenue Circle District, Hubri. Full stop. According to petitioner, the said plot of land is a government khas and seeding surplus land. And the said fact was recorded in Khatiyan number 46. Wherein the name of the petitioner, the petition in interest of the petitioner was reflected as a recognized occupant.
Mal.
Post of para when the state government notified Bosundhara 2.0 scheme for settlement of government khas and sealing surplus lands from the petitioner applied
1612.
page
Page 25.
25.
applied
1612, 20,
for
22.
settlement of such khas and sealing surplus land on 16/12/2022, and the said application was received by acknowledgement number page 25 of the same. So, however, on 17/12/2023, the application of the petition was rejected.
Lordship, it's 17.8.
Hmm?
17.8, page 26, last
Okay,
column.
17/8/2023.
Yes.
On the ground that on field inquiry, the land was found to have been encroached in recent years in organized basis, and therefore the said land stood excluded from the purview of Mission Bosundhara 2.0 scheme. Full stop. Para. The petitioner has disputed the reason recorded for rejection of her application by the order dated 17/8/2023. So the petitioner has further mentioned that before rejection of her application, the petitioner was not afforded any opportunity of hearing, and the reasons recorded are not as per situation prevalent in the ground. So be that as it may, Ms. Bordole, Learned Standing Counsel, Revenue Department, was requested to obtain instruction as to whether, after rejection of the petitioner's application for settlement of khas and seeding surplus land, Mission Bosundhara 2.0, it would be available for the petitioner to submit a fresh application under Mission Bosundhara 3.0 scheme, which is stated to be in currency. Full stop. Ms. Para, good name is Bordole. has placed a copy of a letter, office letter bearing number so and so dated 14/5/2026, received by her from the Revenue and Disaster Management Department, Government of Assam, wherein it is mentioned that the service for the settlement of government costs and sealing surplus land, Assam Mission, under Mission Bosundhara 2.0, has been rolled out perpetually via the Seva Setu portal, as per government notification ECF number so and so dated 15/10/2024. Full stop. In view of it has been further apprised that the petitioner can apply for land settlement through the Seva Setu portal as per the existing guidelines. Full stop. As it is open for the petitioner to file a fresh application for settlement of government costs and sealing surplus land, the petitioner shall file a fresh application for settlement of government costs and sealing surplus land by complying with all the requisite formalities as per the existing guidelines through the Seva Setu portal. Full stop. Therefore, this petition is closed.
My lord, otherwise, Vasundhara 3.0 has already been filing application is it was extended up to February 2025. So it is now closed. I don't know whether this information is correct or not. There is no scope for reapplication in the Vasundhara
This
3.0.
point was discussed in last occasion, Your Lordship, when the matter was listed. So when I obtained the instruction telephonically, I placed before Your
That
Lordship.
is why I have
written yes,
asked
Your
to
Lordship.
obtain reading.
Otherwise,
If face any obstacle in submitting, then you are at liberty,
Yes, Your Lordship.
right? I am keeping this copy of the order with the case record.
my lord, another submission will be recorded if any adverse decision is coming forth, then my personal hearing or
In the event,
opportunity of being hearing
so-
my lord, provided. Absolutely.
in the event the petitioner submits a fresh application, the respondent authorities, while considering the application, shall duly consider the petitioner's claim regarding the long, continuous, peaceful, uninterrupted possession of the plot of land measuring 1 katha in Dag number 137, new stroke 100 old, situated at Revenue Village, Mamunpara, part number 1, Mouza Bilahipara, Bilahipara Revenue Circle, District Dhubri, and the fact asserted by the petitioner as regards reflection of the petitioner's reflection of the name of the petitioner in interest of the petitioner in Khatian number 46.
Lordship, one observation, Your Lordship, the application got rejected on 2023 August. They have filed it in this year, Your Lordship, 2000, after three years, Your Lordship, almost.
Let us file. Let him file. Let her file it. Post of. It is needless to mention that in the event the petition first application is found it is the consideration of the petitioner's application must be with a regent order. Post of. In the event the petitioner feels herself agreed by disposal of the application, the petition would be at liberty to seek appropriate remedy as permissible under the law.
Lordship had
The
directed.
copy of the letter number so and so of the Revenue and Disaster Management Department, Government of Assam, placed by Ms. Bodolo is kept to the case record by marking it as document so and so.
Lordship, item 5,
Item
item
same.
10, and item 31.
5.
No. 31.
Long continuous say, measuring 15 lesser, huh? Tag number 137, new, old, same thing. Same thing. Petition number 46, same thing. J handling, J handling, junior government, 3 and 4. Then 6.
Not
And
6,
10,
10,
and
10.
4, 5, 10, 31.
Okay, Mr. Dasun.
Yes, ma'am.
10,
Yes,
10, 31.
Same,
Bamunpara.
Khatian is not same.
Bamunpara is same.
Yes,
Petition number 12 and 15.
Khatian
12
number
and 15.
12 and 15, Your Lordship.
5 bigha. How many petitioners?
There are 2 petitioners, my lord.
2 petitioners. Huh?
They have shared here, my lord, not total land is
5
possessed by.
bigha and 1 katha
Yes, my lord.
and 11 lesa
Yes.
covered by tag number so and so. Bamunpara same. Part 1. Bilachi Para Revenue
This is a
Service.
share out of this 5 bigger.
And what is the date of the application? Please write down in a piece of paper.
Applications, my lord.
Page 60 and 61.
Yes.
60, Your
Yes,
Lordship.
yes.
Page 60 or 61, huh?
This is
Order
22/12, 2024.
Page 60 belongs to which one? Hanapali.
Napali.
Second one is 61 Mohibul.
Mohibul Ahmad.
Same region. Region is same.
Yes, same.
Encroached in recent years.
60 or 61. Tag number paternal. 31. Yes, Mr. Sharma.
At page 15 and rejection is at page 15 last portion.
Just a minute. One petitioner, right?
On the one.
Your land details, tag number 1 katha 5 lesa, tag number 149. Number 2, Paschim Boragaon.
31.
Within bracket, Paschim Boragaon non-K. Gauhati Revenue Circle, District Kamrung Metro. Our position since 12/10/1996. Our application details to us there.
Page 15.
Page
15. Online.
15.
1/5.
Page 18, I think.
18 also, Your
15.
Lordship.
15.
15 and 18. 18, the date is given, Your Lordship. 16/12/2020.
Application is page 15, application number. Page 15. Our rejection order, page 18. Vulnerable to landslide, Babul Boro, 13/10/2025 rejection
Yes.
order. Same order.
Well, if any adverse order is, I mean.
The same
Yes,
observation.
ma'am.
Same
I
observation.
will submit the
We
document.
will be issuing a reasoned order, Your Lordship. Why?
Regional.
If gets rejected, why it's rejected?
Must be accompanied by region order.
Yes, sir.
After hearing the parties. After hearing the parties.
That may not be hearing, this is not a,
Your Lordship.
not a right,
Only opportunity to submit by particulars, madam.
Only a person.
Online submission, your lordship.
Online submission, with all the, I have said, all the requisite formalities.
If any adverse order is passed rejecting, then before rejecting,
It will be region order.
yes,
Even order.
It will be region order and you will have the opportunity to assail it.
before passing the order, I may be hurt. That is the
Lordship,
if
that opportunity, your lordship.
opportunity only.
Online, sometimes it is not possible to hear personally, your lordship, because so
If
many
possible,
people.
It is a notified service.
Yes, that's why, your lordship.
Notified service.
Yes.
If possible.
Whether it permits,
In
under the
Vatkund,
RTPS Act, it permits.
RTPS, lordship,
That
everything is
even
done
a
online.
public service, a public servant has to hear the applicant.
Yes,
Online, your lordship, I don't think it is possible, your lordship. Humanly, it's not possible, your lordship.
We'll look into the provision. If there is something for.
As per the law, your lordship, they'll do according as per the law. Oblige, your lordship.
Item 6.
Yes, Mr.
Your Lordship,
Goswami.
I have instructions.
Your Lordship, may kindly pass over the matter for the time being, Your Lordship. Senior.
Let us have the first-hand knowledge.
What's it? There's some tag mark is there. Lordship. The report is there. Oh.
Okay. I think
Lordship. That application is pending before CCJ decision, Mr. Lordship.
report has been submitted.
Yes.
Okay, and let Mr. Kaur come.
Lordship. Item number 7.
Yes, Mr. Chaudhary. Let it be after some time then.
Yes. Item 8. In this case, the allegation,
Heard, bank account freeze.
yes, your lordship.
Heard Mr. D. Sharma, learned counsel for the petitioner. Miss,
Lordship, I'm for respondent number 125.
Miss,
A Sharma for B Chakrabarti.
Miss A. Sharma, learned counsel on behalf of Mr. B. Chokrabil, learned central government counsel for all the respondents.
Lordship, 125, Lordship.
1 to 5? Okay, 1 to 5.
6, 7, Lordship.
7?
7, Lordship.
I think 7 will do
Yes,
also.
Lordship.
7
7.
also. 6 by notice, huh?
Yes.
1 to 5 and 7. Comma. Para. The petitioner had opened a savings account in the India Post Payment Bank and the post office Machko, Karachi, district Dhamaji. Which is the petitioner has been maintaining the account number with CIF number and IFSC code number in the Machka post office since then. Full stop. The petitioner desired to obtain financial benefits under the PM Kisan scheme through the state postal savings bank account to survive since the petition has come to learn that the state postal savings bank account has been kept frozen on the basis of a police report from Gujarat Gandhinagar Police Station. Gandhinagar Police Station, Gujarat. What is UPT? What is UPT? I don't understand these abbreviations.
UPI, Lordship.
Huh?
UPI, Lordship.
UPI.
Yes, your
Okay.
lordship.
For UPI related frauds. Post of the it is further learned by the petitioner that it is further learned by the petition from the Citizen Financial Cyber Frauds Reporting and Management System, within bracket CFC FRMS. The account of the petitioner has been frozen in terms of a report from Pethapur Police Station, Gandhinagar, Gujarat. Pethapur, Gandhinagar, Gujarat, within bracket, respondent number 6 for UPI related fraud on the basis of a complaint dated 24/9/2025 for a transaction amount of rupees for allegedly EPI fraud of rupees 5,000. Post issue notice returnable on so and so. As Ms. Sharma has appeared and accepted. Notice. Let to review 1 to 5 and 7. So formal notice to the said respondents with this benefit However, the land counsel for the petitioner shall furnish requisite number of extra copies of the petition along with annexure to Ms. Sharma within 2 working days from today. The petitioner shall take steps for service of notice. I'm going to use number 6 by speed post within 2 working days from today.
Lordship, only page number 9, the requisition was only to hold Lordship 2,000 rupees, Lordship.
The respondent authorities
Or page number
shall
19,
obtain
Lordship.
instruction.
And therefore, Lordship,
The
I may be
respondent
allowed to operate.
respondent authorities shall obtain instruction by the returnable date as to whether the petitioner can be permitted to operate the postal savings account by keeping the lien over the allegedly disputed transaction amount.
1706. Item 9.
No, can it be taken about Wednesday, Lord?
Yeah. Mr. DCC, who can learn counsel for the petition is present, Mr. Goswami. Learned junior government with some claim for the respondents has sought for time till Wednesday ki hogo, date to 20/05/2026 to obtain the necessary instruction in deference to the order dated 11/2026. Release the case accordingly on 11.
Man of date.
2005. Next Wednesday.
Item number 12. Item 12. Item 13.
Lordship, I am aggrieved by my rejection of renewal of passport application.
Okay. What is this Gazette notification 25/8/1993?
My lord, it says, my lord.
Why have not you brought it?
My lord, that is 16, my lord.
16 I have seen, first paragraph, that main notification is 25/8/1993.
Not get, my lord, I tried. But
Okay.
it reflect, my lord.
No, that I have seen. Okay, who appears for the respondents? Mr. Goswami,
I am for respondent 1 and 2.
respond number 1
and
only.
2.
Okay, then Mr. 3 and 4 by state. But 2 is also an important party.
Yes, my lord.
Would you want to have it by Dusty also?
Yes, my lord, Dusty I can.
Huh? Heard Mr. T.R. Sharma, learned counsel for the petitioner, Mr. U.K. Goswami, learned central government counsel for the respondent number 1, and Mr. N. Goswami. Oh, public prosecutor.
In fact, I can also appear for respondent 2.
Okay. And respondent number 2. Mr. Goswami,
My lord.
State of Assam, represented by public prosecutor.
It was
Would it be possible for you to accept?
sorry.
Basically, it is Home Department.
Lord, I can take lodge.
I'm a junior government advocate for the respondent number 3 and 4. Those two.
3 and 4.
Para. The
The
petition
passport.
has claims to be the owner and director of one Messrs. Dumik Educational Consultancy Private Limited, Gauhati, which provides career guidance to students on different fields. Post of. In the course of its business operation, an affair Caused by one Dr. Jadunath Buraumai came to be registered as Bhangagar Police Station case number 342 stroke 2022 under section 420 and section 406 of the Indian Penal Code. Full stop. After investigation, a charge sheet came to be submitted in the said case, right, charge sheet number 235, day on 27/12/2023. Full stop. Para. The petitioner holds a passport bearing number M5178178, which was issued originally on 14/1/2015 with a 10-year tenure. First of as the period of the passport was to expire on 31/01/2025, the petition applied for renewal of her passport while an application after expiry of the period of
Yes, my lord.
the passport on 31/1/2025, the petitioner submitted an application for renewal while an application bearing number para 5 on 11/6/2025. First of the passport authority, after receipt of our application, processed the same for renewal. First of, but the petitioner has come to learn
I was intimated on 8/9/25.
on 8/9/2025 that the application, the renewal application had been objected to due to adverse reports submitted by adverse report received from the police home department. Which report has been based on Bhangagar Police Station case number 342 2022. First of para. It is a case, the grievance of the petitioner is that Mayor registration of an FIR or filing of a substitute does not preclude a passport holder to get renewal of the passport. And in the case of the petitioner, the respondent authorities, more particularly, the respondent number 2, have, including the respondent number 2, have arbitrarily rejected the application for renewal of the petitioner's passport. Issue notice returnable on so and so as Mr. Goswami 1 and 2. Mr. U.K. Goswami, CGC 1 and 2, and Mr. N. Goswami, New Government Advocate 3 and 4. No formal notice, extra copies. The respondent authorities shall Mr. Sharma, learned counsel appearing for the petitioner, has submitted that the application for an application for issuance of passport or its renewal is to be processed in terms of a circular dated 21/8/2014 of the Ministry of External Affairs, Government of India, Annex 3, and a gazette notification dated 25/8/1993. But, the respondent authorities in processing the application of the petitioners application of the renewal application, processing the renewal application of the petitioner did not adhere to the said, to the procedure laid down therein. The respondents shall also brought or the respondents shall in their counter affidavit shall also bring on record the Gazette notification dated 25/8/1993, on the basis of which the circular dated 21/8/2014 had been issued.
1906.
The names of learned counsel will be replaced. Yes, our name is followed. 1906.
The name of the learned government applicant, Assam, be reflected in the respondent side in the corpus.
Deeply obliged.
Item 14.
May please, your lordship. Lordship, my account has been frozen without notice, your lordship.
Okay, Mr.
K. Dekas.
Hard Mr. K. Deka, learned counsel for the petition. The petition has approached this court by the instant requisition agreed by freezing of the savings bank account number so and so maintained by the petitioner with the respondent number 2 bank. First of it is a contention the petition is that since January 2026, the account has been kept fixed by the respondent to purportedly on the basis of a cyber complaint. Post according to the petitioner, no, the petitioner has claimed that no notice had been served upon the petitioner prior to the decision to decrease the bank account of the petitioner, and the provisions of section 107 Bharatiya Nagorik Surakha Hanita 2023 was not followed. Also, issue notice same return. So any respondent by CGC, the learned counsel for the petition shall serve a copy. Mr. PK Medillikable, learned Senate counsel for the respondent one. As Mr. Medi has appeared accepted, respondent one. The petition shall take state for service of notice on the respondent number 2 by speed post. We need to open this one.
1706. Item 15.
May I please, your lordship. In this case, my lord, the petitioner has to come, my lord, again file the writ petition, my lord. The first writ petition was filed earlier, my lord. One eviction drive was taken, my lord. On the day of eviction drive, my lord, the petitioner was under possession of land covered by that number 1084. But my lord, while in the eviction process, the daughter of the petitioner died, my lord, due to care psychosis and all. Then, my lord, the matter has been taken in different way, and the authority has considered the case of the petitioner to make settlement over the other land. That is, your lordship will find at page 64, annexure H. Subsequently, my lord.
Directing husband to make settlement of petition over Sohar Ulubari.
Yes, my lord. Annexure H, page 64.
Annexure 8, page 64.
This process has been later taken on to make settlement in respect of the petitioner, my lord.
Again, proposal of family of Sandra Devi died received from Joint Secretary Kihab Murti Hamna Committee. As per provisions. Yes, 64 thereafter.
Yes, thereafter matter was processed, and the matter was even gone to the placing the matter before the subdivisional level committee also, man. Your lordship will find last annexure, page 100. And relevant part is at page 104. resolution number 89. Subdivision level advisory committee found that the land over which the settlement of the petitioner is to be made is a reserve land. 104, resolution number 89.
Okay, heard Mr. B. Shinha, learned counsel for the, yes, Mr.
This land falls within Go Reserve, my lord. Cannot be probably D Reserve after the job fall.
Thereafter, my lord, for
You were
D
in
reserve.
You were in possession of that plot of land?
Only
No,
possession.
I am not in possession of that. I
Now-
was in other land when eviction drive was taken place. So my house has been damaged half, my lord. Then, my lord, my daughter died, my lord, due to out of fear psychosis of the eviction process. Then this
So
process has been
you
initiated.
are you are not in possession of a land which is included in resolution number 89.
Yes, my lord. No, I am not in possession, my lord.
But proposal was made.
Yes, proposal was sent and D
But
reserve.
that was rejected because it is Go reserve, because that has to be de-reserved.
D reserve. So D reserve.
And in respect of which land you are in possession?
No, now the thing is that I have come before this court that settlement may be made. Settlement may be made because the de-reserve process has been initiated on my lord 5/1/2021, annexure is page 88, to settle me over this land that Ulubari Mauja under Dag number 90. Page
That
88.
land, Dag number 90.
Yes, Dag number 90, which was found subdivision level committee as a reserve land. So, my lord, that has been processed for de-reservation, my lord. There is page 88, my lord.
Page 88. It is a deputy commissioner.
Yes, my lord.
He said that let us de-reserve.
De-reserve the land. The
Right.
process is still going on, my lord. So, I am praying, my lord, that settlement may be made.
Right.
Yeah.
No, I am confused with the.
Oh, my lord, yes, my lord. The confusion is that I was in possession of, I am in, still now, I am in possession of 1084. That number 1084 land.
That is for that reason.
Yeah.
You are in not possession. You are not in possession
Yes,
of the
yes,
land
Ulubari 9.
for
Ulubari
which
that.
proposal has been submitted.
Yes, serviceman.
So you want to challenge that rejection.
Not
You want to
rejection.
challenge that rejection.
No, I am not.
Otherwise, this has been rejected.
Yes.
On the other hand, deputy commissioner has made the indication that
Yes, my lord.
let us have a
De-reserve.
proposal for de-reservation.
Yes, de-reservation. So that
And-
will be completed, my lord.
And you are not in possession of that
Yes, yes,
number
yes.
90.
Not in possession.
I am confused with the
Earlier,
pyramid.
earlier land was in their possession, but he has been evicted from there.
I am confused with the interim prayer.
Interim pair. Interim pair is that earlier land where I am in possession till now, my lord, half. It was halfly evicted, my lord. Not fully evicted, my lord.
Where
That-
from it can be gathered, halfly evicted.
My lord, your lordship may kind of look into this.
Because in the interim prayer, you have not made anything
Interim
specific.
pair, I have said that till my lord, this de-reservation process is completed, I may not be evicted from the earlier land, my lord, because they have initiated the process of settlement. Arising, the cause of action arose from that, my lord, 1084 land, my lord. When they have found that death has occurred, my lord, so for rehabilitation, they have initiated the process, my lord, by the district administration. I am still in the earlier land, my lord. Till that settlement process is completed, I may be, my lord, allowed to be stayed. After, my lord, eviction process has been, my lord, done,
When eviction process was
in
made,
the first week of July, in 2014, my lord, your lordship will find some this paper publication has been made, my lord.
where you stated in the petition, writ petition. Let us go by your statement in the writ petition.
Yes, my lord, yes. I have stated, my lord.
In which paragraph? Heard Mr. B. Sinha, learned counsel for the petitioner. Mr.
Two, good, brother, we good.
Aforesaid,
2 and 3.
learned
2 and 3 also is there, my lord.
Standing Counsel Revenue Department for the respondent number 1. Mr. B.J. Talukdar, learned senior counsel listed by Mr. P.K. Medi, learned state counsel for the respondent number 2 and 3. Post of para, the petition has stated that she is in possession of, she was in possession of a plot of land measuring government plot of land measuring 1 kata 5 lasses covered by DAG number 1084, situate at Revenue Village, Ulubari, Mauja Ulubari, District Kamrup Metro, within bracket, subject plot number 1, or short, full stop. An eviction process was carried out in the year when?
2014, my lord.
In the year 2014.
July 2014.
July 2014. And during the eviction process.
Page 6, my lord.
During the eviction process.
Page 6, my lord.
Subsequently, no?
Comma. A part of the house built by the petition on subject plot number 1 was dismantled. Posted. The petitioner has projected that having failed to bear the fear of eviction, the author of the petition expired. Poster. In the subsequent period, comma, a proposal was initiated by the district revenue authorities to allot stroke settle an area of land, a plot of land measuring 2.58 R, covered by DAG number 90, situate at village Ulubari Part 3, Ulubari Mauja, within bracket the subject plot number 2, in favor of the petition, and the feedback is reflected from an office letter dated 5/1/2021, within bracket Annex RS, whereby the additional deputy commissioner in charge Land Settlement Branch, Kamrup Metropolitan District, asked the respondent number 3 to submit a proposal for de-reservation of the subject plot number 2, as the subject plot number 2 was shown in the land records as go reserve. The matter for allotment stroke settlement of subject plot number 2 was processed subsequently to submit on. What is the date of this order? 106.
106, my lord. 25/4/19.
Oh, that is prior to eviction.
Yes, prior to eviction.
Now new proposal.
Yes,
How can this rejection will come in the way?
Yes, madam.
It cannot come in the way.
Yes, madam.
That is an advisory body only.
Yes, my advisory body only.
Okay. The petitioner has preferred the petition seeking a direction to the respondent authorities for settlement of the subject plot number 2 in her favor as more than 5 years have elapsed since 5/1/2021. Post of issue notice for returnable answers. And is there any fear of eviction from subject plot number?
Dismissal is going on, my lord, everywhere.
Huh?
Everywhere it is going on, my lord. It is going on.
Should notice returnable on so-and-so as Mr. So-and-so and Miti. Huh? Where the petitioner has asserted that the petitioner is still in possession of subject plot number 1 with the dismantled house. With the house dismantled during the eviction process carried out in July 2021. As the petitioner case has been processed for settlement in respect of the respondent number subject plot number 2, the petitioner has an apprehension that before finalization of the settlement proposal in respect of subject plot number 2, C might be evicted from subject plot number 1. So in such beyond the matter, it is ordered in the interim that the status quo as regards petitioner's position in respect of the subject plot number 1 shall be maintained by the parties till the returnable date.
19(6). Item 16.
Major. Matter relates to matter non-granting of mutation, my lord. Non-granting of mutation. Non-granting of mutation.
Non-granting of mutation.
My lord, the petitioner's mother, my lord, she died in the year 2023. She was.
Mother became the Sima, the city owner.
My lord, after she died, my lord, we applied for mutation in the year 2024. But at that time, we are not granted mutation, saying that there is a boundary case, boundary case that is pending. Because of that reason, we are not granted mutation. Thereafter, my lord, the boundary case has also been disposed of, my lord. That your lordship will return. Page 20, my lord. Page 2021.
Applicant Dalini Boro.
Boundary case, demarcation case number so.
This is by some Dalimi Boro.
Dalimi Goro filed the boundary case and in respect of this land, wherein my lord, petitioner's mother is also having a land. So this boundary case was disposed of and her prayer was rejected. But my lord, one of them is a co-partner, my lord.
What is your mother's name?
Begum Nasima Ahmed.
She purchased 1 bigha 10 lesser.
Yes, madam. 1 bigha 10 lesser.
Okay.
But registered sale did.
Okay.
But Dalimi Guru actually filed a writ petition. Initially, she filed a writ petition. Thereafter, on the basis of the writ petition, a proceeding took place regarding cancellation of mutation. Thereafter, my lord.
After your mother purchased this land, whether her name was
yes, my lord, that is a
recorded in the land records.
Yes, my lord. Annexure 1, my lord.
Just a minute.
Assam is in page 14, my lord.
Just a minute. Where is the order you have shown just now? Page? Demarcation case, Dalimi Boro.
2021, my lord. Page number 20.
Page number 20.
20 and 21.
Hmm. 20.
The demarcation case has been disposed of.
Just a minute. Jamabandi.
Jamabandi, page number 13 and 14.
In the Jamawadi 1.71 bigha,
1 bigha,
7.27 lesa.
yes.
Hmm?
Yes. Now, my lord, I just want to point out one thing. My lord, now we have been verbally informed that another co-partaker, my lord, who filed a writ petition in connection with the said boundary case, my lord, that has been pending, and so they are not granting us mutation. That is your lordship, and it starts from page number 23, my lord.
When did you apply for mutation?
In the month of December 2025. Earlier it was on 2024.
Where is that? Any
My
document?
lord, page 22. My lord.
Huh?
Page 22.
Page 22.
22.
Your application by right of inheritance has been submitted successfully. Huh. There it is clearly mentioned, if the service is not delivered, file an appeal.
Anything is that, my lord?
Because right of inheritance, mutation by right of inheritance.
Yes.
So if the process has not been, sorry, if the service has not been delivered,
But here,
there is a process of filing an appeal.
here they have informed us that only because of this pendency of this writ petition, my lord, they are not proceeding with the mutation.
Where from it is they have informed?
My lord, page number 28 is the writ petition, my lord. This has been
In
filed.
one connection, it is in
With
what connection?
Connection was there, this related to the same boundary case, my lord.
Boundary case has already been dismissed.
Yes, well, but this case is pending, and so they are not proceeding with the mutation case. This case is yet to be disposed of, my lord. During the pendency of the case, the mutation case, that boundary demarcation case was over, my lord. My lord, may I kindly see the prayer, my lord, in the page number 47, 48, my lord. 47, 48. Yeah, lordship, in page number 48, pending disposal of the writ petition, your lordship may please to state a further proceeding in connection with boundary case number so and so 13/22. So this order, my lord.
So far that interim prayer, demarcation case number, that is at page 2021, right?
Demarcation case number
13/24. That has become infractious.
Yeah, this is that although this is become infractuous, but since this matter is pending, so they are not granting us the mutation. Well, if your lordship may direct that this matter may be tagged along with this case, then my lord, if any order is passed, then they will.
What is the order passed in that? You have annexed the entire writ petition.
That is pending, my lord.
That is pending. What is the order passed?
Order passed means, my lord, only notice was issued in this case, in that case, my lord. But not, no interim was given, my lord.
Mr. I. Chaudhary, Learned Counsel for the petition, has submitted that the issue raised in this petition is connected with the issue raised in another petition, WBC number
6489.
6489, 2024, which is pending before this court, and is sought listing of this writ petition in the motion column along with WBC number so and so. Lay the case accordingly on so and so with the case record of WBC number so and so.
2505, Monday.
Oh.
I don't know, 17. I don't know, 17.
There is no representation on behalf of the petitioner to the call. Mr. S. Doctor. Now standing out to Panchayat and Rural Development Department. For one 3, 4, 5. Then, it is always management council, state minister, the committee, management council, for the response number. You are present. Let the case be listed again on. Next week.
Tuesday.
Next week, next week, next week.
Next week Tuesday.
No, no, motion no. Wednesday or Friday, did you?
Next week for motion, my.
29/05.
Hello, please.
Item 18.
Please, your lordship.
Yes.
My lord, the petitioner before your lordships is a company, my lord, and they are doing some ongoing projects, ongoing government and PSU contracts, my lord. And there are 4 banks. These are the Punjab National Bank, Bank of Baroda, Indian Bank, and one Canara Bank. So they have taken financial help from all these banks and pursuant to that they were on ongoing projects are going on. Now, my lord will kindly see there are a few list of dates which your lordship wants to, I want to draw your lordship attention. When the financial position, financial was in distress because of COVID, CA hesitation and high receivable from ongoing project contract, my lord. There has to be a restructuring of this particular company. Accordingly, my lord, we applied for restructuring and revival process of the company. If your lordship kindly see at page 45. This is a list of dates. Lordship will kindly please note down I am an MSME, my lord. So now my lord will kindly see 1/1/2026. This is a submission of restructuring and revival proposal of the company. Lordship got it, my lord? At page 45, my lord. 1/1/2026. And my lead bank is, my lord, Indian Bank. And we have written to them.
This restructuring and revival proposal of for what?
Debts, my lord. Debts. Because these were NPA account, my lord. So repayment of this, my lord, loan.
Basically, the financial facility which was extended to the petitioner, that requires modification.
Yes.
Other than restructuring of the company is a different issue altogether.
Yes, lordship is correct in
Because
this.
restructuring is
Restructuring means, my lord,
subject
and revival process. What was there initially, my lord?
not a financial facility, perhaps.
Financial, but this has to be totally restructured, the financial, my lord.
No,
That's why maybe your lordship is right. Your lordship is right.
Restructuring of the company is a different matter
Yes.
altogether. It is
Finance. Your
under
lordship
the
is
company's law.
Your lordship is absolutely correct. It is financial. I correct, my lord. It is financial. Your lordship is right. Now, my lord will kindly see this policy at page 45. We have written to them, and at page 47 is the comprehensive, my lord, plan, my lord. I'll call it as a plan, my lord, comprehensive plan at page 47, my lord. Now we have given we are MSME, my lord, and status and eligibility at page 48. All this was indicated to them, my lord, by way of filing this application before them. But unfortunately, at page 62, my lord, your lordship can note down the date. That is on 17/1/2026, my lord, at page 62. I'll note down, my lord, 17/1, which indicates, my lord, at 62, Saturday, 17th of January 2026. Lordship got it? Now, please see, my lord, 3 lines. In reference to your proposal in account of so and so, a joint lender meeting was conducted on 16/1/2026, when it was unanimously decided by all banks not to proceed with of your account. Lordship got it, my lord? So it was ejected with 3 lines. Hence, the proposal stands decline. Please note down, my lord. Hence, the proposal stands decline. Lordship
So
got it?
basically restructuring of the account.
Yes, correct. Hence, the proposal stands, my lord, decline. Now, at page 63, my lord, 23/1/2026, my lord, again we submitted a fresh restructuring, my lord, of finance. We'll call it this way, my lord, at page 63, 23/1/2026, my lord. Now, this is at page 65 to 83. Second proposal was given to them at page 65. 65 to 83, my lord. Now, that was pending. They have not done anything. Having no alternative, we have to approach this normal court by filing a writ petition at page 84, my lord. Please see 84, my lord. This is a writ petition which has been filed. And at page 85 is the order of this court on 6th of February 2026, my lord. At page 85. Now, my lord will please see at page 86. In deference of the earlier order dated 3/2/2026, it is informed by learned counsel for the bank that the consortium has taken into consideration the proposal submitted petition on 1/1/2026. Although the subsequent proposal submitted on 23/1/2026 has not been considered, learned senior counsel submits that he has received verbal instruction as the proposal has not been found to be accepted by consortium and therefore proposal is rejected. However, no speaking order in this respect has been issued to writ petition. Under such circumstances, the court directs respondent 1, 2, 3 and also the consortium to take an effective direction and pass necessary orders by way of a speaking order, sub copies thereof on the writ petitioner. Consortium may also consider the subsequent proposal submitted on 23/1/2026. Any details or particular necessary from the petitioner, same ought to be called up by the consortium before taking final decision. After taking the final decision, copies thereof shall be served, so and so. If your lordship, please turn to page 87. Till any such order is passed, no further action can be taken, shall be taken against the petition on the proceeding initiated by the respondent bank. Paragraph 5, if your lordship, I am troubling the lordship, I just left that paragraph 5. Accordingly, these courts grants liberty to the petitioner to approach the consortium by filing necessary representation for a personal hearing if so deemed fit, and if any such application is filed, consortium shall consider same as per procedure prescribed and pass appropriate order thereof on or before 9/3/2026. Now, my lord will kindly see, after the direction of this honorable court on 6/3/2026 at page 88, my lord. Please see 88, the next page. Please see. They have informed, my lord, that this is my proposal is incomplete. If your lordship kindly see at page 88, we have written back to them. This refers to your proposal. Lordship got it?
Yes.
To so and so regarding restructure of your account, we would like to inform during the consortium meeting held on 6/3/2026, the company acknowledged proposal was submitted in an incomplete manner and that the financial projections were not aligned with the supporting documents. Company also confirmed it will submit a fresh restructuring proposal within a week supported by complete documentation and a properly structured plan. Accordingly, we are requested to submit a revised and viable restructuring proposal in full, incorporating the following details with all relevant supporting document. So 1 to page 89 up to 18. These are, my lord, they wanted. This you have to submit. Please note the above requirement inclusive and not exhaustive. Considering the company is expected to submit a complete proposal with all necessary facts, figure, and documentation, your proposal dated is required to be resubmitted again. Accordingly, my lord, at page 90 on 9/3/2026, my lord, this is my lord proposal incomplete. So it was rejected for time being. And 23/1/2026, they indicated, my lord. According to second paragraph, the joint lenders meeting was convened on 6/3 to provide a to company an opportunity to person hearing, deliberate on restructuring request in the presence of all consortium members represented by Indian Bank, Punjab Canada, Punjab and Bank of Baroda. Observation of the consortium, my lord. If you see one incomplete and non-comprehensive restructuring proposal lacking clarity on receivables order book, status, financial projection on a credible turnout plan. Now, my lord, will please see at page 91, decision of the consortium, my lord. At page 91, after detailed deliberation, all consortium members unanimously concluded that restructuring proposal of the company could not be considered in its present incomplete verbal form. Restructuring must be a borrower-driven, support by complete, accurate, variable documents across all lenders, bank in hand, and future work order, status of existing work in progress, capital infusion plan, etc. Since the mandatory documents have not been submitted and compliance issue remain unresolved, proposals stand rejected as of this communication. My lord, will please, as of this communication, as the consortium feels company adopt bits and pieces approach and restructuring exercise being used to halt the genuine recovery process, public money, this concept further decided the recovery actions will continue uninterrupted in accordance respective bank policy and regulatory guidance unless convinced by genuine going concern aspect of the company. My lord, last pair, you may, at your discretion, submit a fresh and complete restructuring proposal in future. Such a proposal must be accompanied by all requisite documents, financial statements, compliance item and credible revival, projections and must be viable. However, the feasibility of restructuring proposal falls solely at the discretion of the consortium. So now, my lord, will kindly see at 92, we file a reply. Next date, immediately we file a reply on 10/3/2026, covering all those 18 points which they have. If you see second paragraph, my lord, at the outset, lordship got it, we wish to submit here that we had sought a time up to 15 April 2026 for submission of detailed revised restructuring proposal. However, we had mentioned that we shall provide timeline for all submission related document in next 2 to 3 days. We further submit that we have already started work on the same and will endeavor to submit the same by 10th of April 2026. As regards so and so. Now, my lord, at page 95, we sought for a temporary operation of the account to execute the ongoing project. But on 96, 10 April 2026, as my lord, we have written back to them, this was fresh detailed proposal was sent to them, was submitted to them. Now, all the points was covered. It is from page 96 to 283, my lord. First paragraph, my lord, your lordship, troubling with the first paragraph, if your lordship so permits, at page 96. This is with reference to the constituent meeting held on 6/3/2026, wherein we are informed that we shall submit a revised restructuring proposal by 10th of April 2026. We also refer to your email on the same date wherein certain information was sought as a part of restructuring proposal. We now submitting our revised restructuring proposal enclosed with this letter, sending along with this following information, part of which was also shared earlier, email dated 10/3. But for the sake of providing complete clarity, we are resubmitting certain information along with all pending items. So it starts from page 96 to 83, my lord. Now, the problem is that till today, this is pending and they have not done anything, my lord. That's the whole problem. That's why we have approached this honorable court, my lord. At least let them take a decision, my lord, within a period of 2 weeks. That's our whole case, my lord. And what is the problem in this case? I have filed a second case also before this court. This is what has happened, my lord. We're doing some ongoing projects, my lord, in Meghalaya. There were some 9 bank guarantees were submitted to them. My lord, I'll show in the next case This, my lord, all 9 BGs, bank guarantees were before that. Now, 90% of the work is complete. More than 90. Only 95%. 181 crores, I will show, my lord, it is completed. And only 10% advance. 10% advance. If, my lord, 5 crores is only remaining, they only can 10% mean 50 lakhs. How can they invoke all these 9 BGs, my lord? 18 crores, my lord, they have invoked, which was lying with them. I'll show that. Now, my lord, my case here is, my lord, let the bank decide my proposal, whether they want to accept, they want to reject, they have to communicate to me, my lord. This is what I want, my lord.
This option was given as at your discretion.
Correct, my
To
lord.
submit a comprehensive
Right, absolutely
proposal.
right.
Otherwise, they have
Right,
rejected.
correct, my lord.
And
But here-
thereafter, they have reserved the right.
They have
to
reserved
continue.
their right. Only what I am asking,
So, if all the
with
parties,
your
are,
lordships,
all the parties are present.
yes, I have served a copy.
Yes, Mr. Sharma,
Yes.
all the respondents are represented.
Your lordship, I am
Say, for example, 2 to 5.
your lordship,
for Punjab National Bank, respondent number 3.
Okay,
I am for 2, 4 and 5, your lordship.
2, 4 and 5. So they are the authorities who are to look
Yes.
into the proposal.
Correct, my lord.
My lord, I have not been served a copy as yet, but I represent Power Grid Corporation of India Limited, respondent number 6 in item 18 and respondent
Primary
number.
relief is not against you.
My
Primary
lord.
relief sought by the petitioner is not against you. We don't know what is the procedure for consideration. Yes, Mr. Sharma and Mr.
Your lordship, in this case, your lordship, first of all, they have sold one mortgage asset without letting us know. And after knowing, they have furnished some bank guarantees and all. And thereafter, one SURFACE application is pending before the Debts Recovery Tribunal. That is filed by the petitioner. And beyond that, your lordship, they can make a proposal because settlement is such a thing that can be happened after the judgment. But your lordship, at this stage, since the bank has already declared their account as NPA and bank has taken the SURFACE action.
Bank has taken SURFACE action.
SURFACE action is being taken by the bank under section 13 of the SURFACE Act, your lordship. And against that, they have already approached the Debts Recovery Tribunal under section 17.
There is an appeal.
Yes, your lordship.
Section 17 is
Section-
appeal, perhaps.
Yes, your lordship.
Canara Bank has also filed original application before the DRT for a claim of rupees 46 crores 62 lakh 36,000.
Then we can issue notice at this stage, but pendency of the writ petition shall not be a bar for the bank to consider the
No, your
restructuring
lordship,
proposal
there's
as per law.
Bar.
As per law.
Yes, your lordship. Your lordship, I have already submitted that proposal can be made even after passing of the judgment also. your lordship.
Yes.
Because
So,
settlement is such a thing.
Since they have, according to the petitioner, they have submitted a proposal which is comprehensive. So bank authorities can consider it.
Yes, your lordship, that is
If it
under
is-
consideration.
If it is
the next-
feasible.
If the next JLM will be happened, then
If
it
it
will
is
be
feasible
decided.
for consideration, then you can consider pendency of the other proceeding may not be a bar
Yes, your lordship.
Yes, well.
under the law.
That is our submission.
By SURFACE, that I am also saying that independent. That is independent, my lord.
Maybe it may have a connection, but comprehensive
But further,
submission of a comprehensive plan would not debar the bank authorities to consider it. If it is found to be proper, they may act on it.
Yes.
but only what
We'll
I
not go into that details, nitty-gritties, but you have said that you have submitted a proposal on 10/4/2020.
10/4/2026, yes. your lordship.
So pendency of this writ petition shall not be bar or any
till
other
they
proceeding.
decide,
Yes, your
till they decide, my lord, they will not take
That decision I cannot impose.
what your
That
lordship.
take a decision within 15 days.
No.
It is not.
That I am not saying. I will not say to your lordship also that your lordship will say that take a decision within.
I
That
can
of
only
course your
observe.
lordship is right. But I am seeking what is that the bank themselves has stated that if you want, you give a fresh proposal
Right.
covering all these 19 points.
That I
And according,
observe.
my lord, what we want to maintain is not that this is a company. Ongoing projects, I will show it in the second case, my lord. A huge case. My lord, during the COVID, I will just digress a few
So
points.
you have been given the option to file a fresh and complete restructuring proposal
Yes.
in the on
On 10/3/2020.
9/3/2026.
Yes.
So according to you, you have submitted a comprehensive proposal.
On
Yes.
10/4/2020.
10/4.
Right, 10/4
Yes.
2026. And due to non-consideration, you have approached this court.
Yes.
And there they have also observed that feasibility of the restructuring proposal would be considered by the consortium at their discretion.
Right.
So let them have a consideration.
I'm sure 100%. That's why we have approached this honorable court. Only what I is saying, my whatever part they have done it, but they will not take any coercive measure till they decide.
What?
Any father, I am saying, my lord, what they have taken is taken, my lord. What? No, any father, because there was an order, my lord. I am not saying that.
That has got extinguished.
No, that's your lord.
That order has got extinguished.
Because during the your lord.
With the order on
On 86,
6/2026, High Court has ordered.
Yes, this order was passed.
That was
6/2026.
Yes.
But that was also, my lord, where my lord repented.
No, there are so many other litigations pending.
No, what I am saying.
Where the power is available to the designated forums.
Yes.
To have some other actions.
That
by this petition, just because your financial situation is in disarray.
No, my lord, I am not saying in 1 second also that your lordship
this
will
is a very
say.
broad term, coercive action.
No, what I am saying, your lordship, I am not saying further also before this court that do something which is not possible. I will not do. Whatever further, my lord, action, they will not. My lord, we want to, it's not that a one-day relation with the bank, my lord. This is a huge project which we are running this project, my lord. Some few crores, my lord. 300 to 400 crores, my lord. We have a relation with the bank. They should also understand, my lord. Only I'll show it, my lord, why they have done it.
Because,
my lord, why they have done
it? There are others, they have said, they have invoked surface provisions. They have said, but you have preferred an appeal under Section 17. They have
we are not
invoked
asking,
Section 13.
Please do not misunderstand. We are not asking for any stay of those proceeding.
No, coercive stay means very broad term.
My lord, your lordship will indicate here itself that no further, my lord, in respect of till deciding this particular representation, my lord.
That they have made it clear that that is their discretion.
No, that is them.
It is clear.
But my lord, restructuring.
They have made it clear, sir.
No, that's I have seen, my lord.
Page 91.
Yes, I have seen that. Page 91, my lord.
You have given an option only.
No. That's true, my lord. But 91.
Coercive action is very difficult at this stage. We can only observe the pendency of this petition or any other proceeding, if permissible, shall not be a bar for the consortium to take a call on the comprehensive restructuring proposal given by you in the meantime.
Yes. But only what I am, my lord, what I am
Coercive is very broad.
With great respect, I am just praying before this honorable court that only whatever they proceeded, I am not saying for an inch also that your lordship will protect.
How can we interfere with an order restructuring of financial facilities? So us, in this kind of situation, your accounts have been declared NPA.
Your lordship
without doubt.
Yes.
Now, banks have extended you public money.
Yes.
Now that financial situation is in disarray.
My lord.
They have the first and foremost responsibility to recover it.
My lord, can I just say 1 second? My lord, we did the second petition, I'll share. When the meeting was held by the consortium bank, the NIPCO, my lord, I don't know, the power grid, they have invoked 9 BGs, my lord. 9 BGs, and all this money we were not getting directly. It is during the COVID time, there was a particular scheme, Niti Aayog, because the owner couldn't be present, or they cannot, the subcontractor was directly paid, my lord. Till today, subcontractors are directly being paid. It is not a case. I'll show it, my lord, before this honorable court, the second case, my lord.
But sorry, in this case, coercive action is difficult.
But my lord, can I just make it clear, my lord? Let the recovery proceeding go, but they will not take no further coercive action, my lord. Recovery
that is very broad term. And this should be an order under 226.
No, my lord,
That
226.
is very broad
My
term.
lord,
When
I-
they have said, let them place all their proceedings they have initiated, then only we can find out a final part. Otherwise, very difficult.
Yes, my lord, let them, your lordship wants, let them.
Otherwise, pendency of this petition
My
shall
lord,
not
can
be
I-
barred if notwithstanding any other litigation in any other form, let them consider if your comprehensive structuring proposal, restructuring proposal is found feasible, they may definitely, instead of going, nobody wants to go to the litigation.
That's what the last.
Right.
That's the last,
It
my
is the
lord.
last resort. If
Yes.
they find your proposal feasible enough, definitely they will consider. I cannot direct in the interim also that you have to consider.
No, that your lordship can't. How can your
These are
lordship?
banks.
But these are banks. But for restructuring, I will put in this restructuring of the finance.
Right.
My lord, finance. Of course, these are MSME, my lord. These are
Now, MSME has been disclaimed by them.
Yes, my lord.
Mr.
want-
Das,
say-
I have just had a look
Yes,
at the order.
yes. Which order, my lord? Page 85. The order of this court, your lordship is saying.
No.
Which order? Page 90.
Ah.
Page 90.
Because page 90.
Yes. Page 90.
So dispute is as per the RBI framework, revival of MSME as your exposure is more than 25.
Page 90.
Page 90. Your proposal does not fall under the RBI framework of revival of MSME. So exposure is more than 25 crores.
More than 25
I
crores.
thought under
How much?
More than 25 crores.
It will come near about 300 crores.
300 crores. So you are no longer in MSME. Though you may have a Uddam certificate.
My lord, revival may be as per RBI framework, but not MSME, but revival is
not,
per
all right.
revival is per
You have
RBI
said-
framework, my lord.
No, you have made a claim that your revival should be considered under the RBI framework MSME. They are saying no.
They may not, but the framework is under revival.
That is open. I am not, no, since you have,
I am saying.
since you have indicated that you are an MSME.
My lord, I am an MSME, but the revival framework is under the RBI, my lord. May not consider by MSME, my lord. Let them, my lord.
Mr. Didas, learned senior counsel, listed by Mr. K. Talukar, learned counsel for the petition. Mr. Sharma, you are for?
2, 4, and 5, your lordship.
Mr. M. Sharma, learned counsel for the respondent number 2, 4, and 5. Mr.
A. Parvez.
A. Pardes,
Respondent number 3.
learned counsel for the respondent number 3, and Mr.
N. Khera, my lord, Nitin Khera,
N. Khera.
for respondent number
Learned
6.
counsel.
Power grid.
You are standing counsel.
My lord, I'm the counsel. We don't have the concept of standing counsel, my lord. I'm a panel counsel for this matter. I'm the counsel.
Learned counsel for the respondent number 6 through the virtual mode. First of para. The petitioner herein is a company incorporated under the provisions of the Company Act 1956, and for carrying out its operation, it had availed financial facilities from the respondent number 2, 3, 4, and 5. Respondent number so and so banks. Any lead bank?
Lead bank is Indian bank.
With the respondent number 2 as the lead bank of the consortium. First of the petitioner has stated that it has a valid Uddam registration certificate issued under the micro, small and medium enterprises development within bracket MS MED Act 2006. Full stop. On 1/1/2026, comma, the petitioner company submitted a restructuring and revival proposal of its account for before the respondent number 2 bank being the lead bank of the consortium for consideration. First of the (23)(1). On 23/1/2026, the petitioner company submitted another proposal for resolution and restructuring of its account. First of when the proposal submitted by the petition company were not found to have received due consideration at the end of the financial banks. The petitioner approached this court by writ petition WPC number 522/2026. First of all, after hearing the parties, the writ petition PPC number so and so was disposed of by an order dated 6/2/2026. With a direction to the financial banks to take an effective, to pass a necessary order, to pass an order after consideration of the proposals, to pass a speaking order after consideration of the proposals. More particularly, the proposal dated 23/1/2026. First of all, it was observed that if any details or particulars were necessary to be received from the petitioner, then the same should be called for from the petitioner company before taking a final decision. And the petitioner, if asked for, should also be heard. First of para. It was on 6/3/2026. The petition company was informed by the consortium of banks through the lead bank, that is a response number 2, that it was concluded by the financial bank after detailed deliberation that the restructuring proposal submitted by the petitioner company could not be considered in its present form, as the same was found to be incomplete. Post of observing that mandatory documents were not submitted and compliance issues remain unresolved, the proposal was rejected was by the communication dated 9/3/2026. So, however, it was observed that the petition company, at its discretion, would submit a fresh and complete restructuring proposal in future, accompanied by all requisite documents, financial statements, compliance items, and credible revival projections with viability and the feasibility of such restructuring proposal, if any, submitted by the petitioner company, would be solely at the discretion of the consortium bank. Post op. In the order, in a decision dated 9/3/2026, it was observed that the petitioner company the accounts of the petitioner company was NPA for more than 1 year. And the consortium had decided that the recovery action would continue uninterrupted in accordance with the respective policies of the bank and the regulatory guidelines, unless convinced by the genuine going concern aspects of the petitioner company. Para. Subsequent to the decision dated 9/3/2026, the petitioner petition company has submitted a proposal for debt resolution on 10/4/2026, and according to the petitioner company, the said revised restructuring proposal has met all the deficiencies indicated by the consortium in its decision dated 9/3/2026. Post op. Mr. Tasla, a senior counsel appearing for the petitioner, has submitted that since the proposal for debt resolution submitted by the petitioner company by way of revised restructuring proposal have complied with all the requirements indicated by the consortium in its decision dated 9/3/2026, the same deserves an early consideration, as it has as its early consideration will have a bearing in the revival process undertaken by the petitioner company in all its activities. Post of para Mr. Sharma, learned counsel appearing for the respondent number so has submitted that the respondent banks have initiated any particular bank. Okay, the respondent number
3, your lordship,
3
and 2 has taken surface here.
has already initiated action under section 13
Yes.
of the SARFAESI Act, against which the petitioner company has preferred an appeal under section 17 of the said Act. Post of Mr. So-and-so, Parvez, learned counsel for the respondent number 3, has submitted that the respondent number 3 bank has also, 4 bank has already initiated a proceeding before the debt recovery tribunal by filing an original application.
65 of 2025. OA 665
Original OA number 65 stroke
2025.
25 before the debt recovery tribunal, and both the all these proceedings are pending. Post of issue notice or returnable to so and so issue notice post of as the respondent number 2 to 6 are represented by their respective counsels, comma, the notice is made returnable on short date cleaning of the learned Mr. Taludar, learned counsel for the petition ourselves serve requisite number of extra copies of the petition to Mr. Sharma, Parvez, and Mr. Khera for the respondent number 2 to 6. The petitioner shall take steps for service of notice upon the respondent number 1 by speed post within 2 working days from today. Post of let notice be issued also on the interim prayer. Post of the land counsel for the parties are heard on the prayer for aid interim relief. Post of
There's only one. I'm sorry for troubling and disturbing your lordship in between. This is 87. If your lordship looks at paragraph 6, my lord. Sorry for troubling your lordship. I pressed 87 and paragraph 6. Paragraph 6.
Paragraph
87 of the order, paragraph 6.
87.
Paragraph 6. My lord, those proceedings were initiated already, my lord, by respondent bank at page 87(6), my lord. Lordship got it, my lord. Paragraph 6. Further action were against on the proceeding initiated by respondent bank. I think prior to that, all the proceedings was initiated 2025. But it was there, my learned friend also appeared.
Your lordship, proceedings has been initiated because
that's
the
right.
NPA is of April 2020.
That's right, my lord.
But SARFAESI application has been
I
filed
don't know.
after writ petition.
I just pointed out. I shall leave to your lordship, my lord. This is what I found now.
Otherwise, I have to interpret this.
No, but it's up to your lordship.
I am conscious of
I know
this entire order.
Yes, that's all. Pending, my lord, let them to dispose of. Pending will not be a bar.
As the issue of revival of the petitioner company is dependent on a consideration of the restructuring proposal submitted on 10/4/2026, comma, the respondent number 2 to 5, which is led by the respondent number 2 as the lead bank of the consortium, shall give an expeditious consideration to the said proposal dated 10/4/2026. And to take an early decision on it, it is expected. Full stop. Therefore, it is observed that pendency of this writ petition shall not be a bar for the respondent number 225 to consider, to process and consider the proposal dated 10/4/2026 in the interim. I have issued also on the interim prayer, notice on the interim prayer.
Right.
8-6.
Take a call. The respondents shall file their response on or before the returnable date, and more particularly shall apprise about the decision if taken, if any, taken on the proposal dated 10/4/2026 on the returnable date.
Can your lordship had fixed a date, my lord? 8 June?
8 June.
8 June. Interim will be considered. Your lordship.
I am keeping it open,
Yes.
keeping it open,
Right. Only doubling.
having considered all the submissions of Mr. Dust.
Yes, yes. My lord.
As an ad interim, I have observed this.
I am deeply obliged. My lord, 21, there is a connected matter if it is convenient, my lord. Because there are two other matters, 1920. My lord, this is a connecting, why I am saying, now my learned friend, Mr. Khera is now for the NIPCO. Now, if your lordship, I'll make it very, if I can make it, I'll make it easier. Well, if I give a note, my lord, here before, Lord, 3 points which is important. Now, my lord will.
You have given these bank guarantees in favor of these banks.
Yes,
right?
in favor of Pargrid. Pargrid.
And it is, these bank guarantees are of which nature? Unconditional and irrevocable.
Yes.
So it is a contract. You are not a party to that bank guarantees.
Correct.
You are, that is an independent contract between the power grid and the bank.
Right.
My lord.
We will proceed on that basis.
Yes, yes.
My
Right.
lord.
I just keeping
My lord.
that. So I am
My lord.
And whether they have been encased.
It is an independent contract. Yes.
Because only 2 grounds can be injuncted.
Yes.
And which is which perhaps are not available.
I am not asking today.
Right.
I am.
And secondly, I think what is the amount of a bank guarantee?
18 crores, my lord.
Okay, and you indicated
18 crores, 19.
and you indicated something about their dues.
Yes, if your lordship kindly see at page 111, is 111. This is a per record, my lord. If you see this, my lord, this is about the work which is in Meghalaya, my lord. Total, kindly see the contract value at page 111. 111.
No, from your submission, I have understood that they have invoked bank guarantees. What?
They have 18 crores.
18 crores.
Yes.
Right.
Yes.
And the dues pending to be paid is how much?
Now 5 crores.
5 crores.
Yes.
So they have invoked in excess of 5 crores. So 13 crores could be returned to you, which would permit you to run your operation. I think that is your crux of the
That
case.
is the crux of the case. Your lordship will issue a notice and tell them, my lord.
Yes, Mr. Khera, have you understood?
My lord.
That is their contention subject to your affirmation.
My lord, I am not in possession of the petition as yet. We have appeared on knowledge.
Do you have any local counsel?
My lord, I have my colleague is there. He'll receive the copies.
Okay. Okay. Assisted by Mr. H. Moyur.
I'll just give a copy to my learned.
Heart, Mr. D. Das, learned senior counsel, assisted by Mr. K. Talukdar, learned counsel for the petitioner. Any CGC? CGC? Okay.
Please issue CD.
Mr. N. Khera, learned counsel to the virtual mode assisted by Mr. So-and-so. Learned counsel for the respondent number 2. Mr. M. Sharma, learned counsel for the respondent number 3, 5, and 6.
Yes, your lordship.
And Mr. Parvez.
Yes, my lord. For respondent number 4.
J. Parvez.
Yes.
J. Parvez.
A
A. Parvez. Learned counsel for the respondent number 4. Full stop.
4.
Para. The petitioner company has approached this court agreed by in encasement of how many number of bank guarantees?
9 bank guarantees.
9 bank guarantees. Have you, is there any table
Yes. Yes.
inside the petition?
Yes.
Which para?
Into paragraph.
Having total value of rupees 18 crore 13 lakh 4,312, comma, is given in the table,
Page 20.
as given in the table in paragraph 33 of the writ petition. By the respondent number 2 on which date? 6/5/2026. Full stop. It is the case of the petitioner that the petitioner company is presently undertaking contract works of what?
What about my lord? 193 crores.
193 crores at various locations. And as on date,
Has completed 188 crores.
it had executed contract works worth 188 crores.
06-20-279. Page 11.
111.
Yes.
Which column?
Which second, the third column?
Okay,
Value?
188. 18806 20279. Meaning thereby, it has to execute balance works of rupees 5 crore 29 lakh 96,000. Full stop. One of the contentions of the petitioner company is that due to encasement of bank guarantees worth so and so, the petitioner company's ongoing contract works have come to a grinding halt, whereas the respondent number 2 is only entitled to
10%
receive
10% of the 10% of the balance work.
10% of the balance work.
Yes.
Such view of the matter, the petitioner respondent number 2 has the action of the respondent number 2 is arbitrary in nature. First of it is a submission on behalf of the petitioner company. That due to such encasement in excess, encasement of the bank guarantees in excess on the part of the respondent number 2 had there been no encasement on behalf of the bank guarantees in excess of its due amount by the respondent number 2, the petitioner company's ongoing contract works would not have come to a grinding halt. Issue notice, same date, returnable on so and so. As so and so, so and so. The learned counsel for the petition shall serve a copy of the petition to the learned deputy solicitor general of India for service within 2 working days from today for service of notice upon the respondent number 1. Full stop. The matter of the learned counsel for the respondent number 2 shall apprise on the returnable date as to whether the entire amount recovered by encashment of the 9 bank guarantees are receivable, are required to be retained, by it or not.
Item number 19.
May I please, your Lordship? Lordship, I am for item number 17, Lordship. I am very sorry, Lordship. I am just.
I have already posted now, no time to return back.
Sorry, Lordship.
It is not that of urgent nature.
May I please, your Lordship? My lord.
Yes, sir.
Yes, my lord, the case here is the petitioner herein, he has pronounced talaq on his wife by talaq-e-Hasan mode. And then he preferred a application before the marriage and divorce
Who will
registrar.
issue notice at this stage?
My lord, may I pray, my lord, that similar kind of matters where before this honorable court and the coordinate benches of this court has passed few orders disposing it to directing the marriage and divorce register to act in accordance with law. If my lord may kindly take the order.
Mr. Talder, look at it, then come back, will come back.
Revenue Department.
Give it to the Mr. Aforesaid, he will come back.
I pay to the sample. My lord.
Let him examine, keep
My
it
lord.
in the, give it back, Mr. Aforesaid, he will post it on today is what?
Today is Monday.
Monday, Wednesday.
Wednesday, my lord.
Release the case on Wednesday.
My lord, oblige.
May I please, my lord? My lord, the petitioner before your lordship purchased a plot of land long back in the year 2001 by way of a registered sale deed from the recorded pattadar. The name of the recorded pattadar was also enlisted in the Jamabandi of the said land. Thereafter, when the writ petitioner applied for mutation, it was stated by the circle officer that the particular land is the government land. So he has referred the matter to the Honorable District Commissioner for taking necessary action. Thereafter, we have got a notice from the district officer that so-and-so date has been fixed for hearing into this matter. In the matter, we have furnished all the relevant papers, certified copy, then the copy of the Jamabandi and copy of the no objection certificate that we have received at the time of registration of the sale deed, copy of the GMDA, no objection, and one certificate that also shows that the land is free from all sealing acts. But in spite of that, our mutation was not granted. Accordingly, we have filed one appeal before the Board of Revenue, and the Assam Board of Revenue was pleased to dispose of my appeal by the order dated, my lord, Annexure 11, my lord, page number 30.
And Mr. A.K. Joint Learned Counsel for the petition.
Page number 53, my lord.
Yes, I have seen. Mr. H.K. Mr. A. Bhattacharyji, Standing Counsel Revenue for the respondent number 1. Mr. H.K. Hazarika, Learned Junior Government Advocate for the respondent number 2, 3, and 4, post of para. By the judgment dated 25/3/2025, the matter of mutation passed in case number 21 RA within bracket K stroke 2024, page 53. The Assam Board of Revenue remanded the application of the petitioner for mutation back to the respondent number 2 with a direction to re-examine the land records pertaining to DAG number 1 and patta number 1 in consultation with the respondent number 4 to verify whether any conversion of the said plot of land to government land had occurred with an opportunity to the petitioner to be heard. Post of Mr. Joint Learned Counsel for the petitioner has submitted that the petitioner is a senior citizen of 74 years, and despite the direction made in the judgment dated 25/3/2025, the respondent number 2 has not proceeded with the application, and no notice has been sent to the
My
petitioner.
lord, one representation was also submitted in the meantime. I had annexed 12.
No notice has been sent to the petitioner till date, despite a representation submitted by the petitioner on 28/4/2026. First of para, Mr. Hazarika, Learned Junior Government Advocate, appearing for the respondent number 2, 3, and 4, has submitted that he will obtain up-to-date instruction as regards consideration of the application of the petitioner for mutation, and has sought for a week's time to obtain such instruction. Lays the case on.
My lord, in the meantime, the respondent's authorities may kindly be directed to maintain the status quo in respect of the land.
That is not the direction of the Assam Board of Revenue. Let them have the instruction within a week.
2905.
Extra copy maybe, sir.
Learned Counsel for the petitioner shall furnish a copy of the petition along with annexer to Mr. Hazarika by tomorrow.
Item 22.
May I please, Your Honor?
Heard, Mr.
Zio Ahmed.
Learned Counsel for the petitioner. Yes, what is the case? Electrocution date
Petitioner,
and APDCL. Who is for APDCL? You are. And who is for power, Mr.?
No, Lordship. Lordship, one necessary party is chief electoral inspector. It is not made party, Lordship.
well, at earlier case, I was
No.
made party, but
He has to be made a party.
Yes, Lordship.
Yes,
We will
Lord.
file an inquiry.
Miss
Yes, Borwa.
S. Borwa, you are on behalf of
PDAS.
PDAS, Learned Standing Council, APDCL. For the respondent number
2 and 4.
2 and 4.
Your Lordship, 3 is not clarified.
Mr. Hazarika, SK Hazarika, you are for
Respondent number 1, Lordship.
Learned Junior Government Board for the respondent number 1. First of Mr. Sorensen, Learned Counsel for the petitioner has sought for a week's time to file an amended cost title. The praise the Lord lays the case after a week. Lays the case after a week after submission of the amended cost title.
Your Lordship, the respondent number 3 is also not mentioned properly as to which council to represent.
See, Mr. There is non-existent board. Respondent number 3.
that's maybe deleted, my lord.
That is up to you, amended cost title. I am not going into that. Correct and file a correct amended cost title.
Item 23.
May it please, Your Lordship.
Yes.
Lordship, 2 bighas of.
Easier.
Were settled in favor of the private respondent.
Settled.
Settled.
Already settled.
Already settled in favor of the private respondent. Your Lordship. Private respondent number 7. There is a cooperative society.
Where it is that it is settled.
The order is not, Your Lordship, may kindly peruse. Stated impugn lordship, but not annexed.
Page 14.
Yes, say impugn stated, but not annexed.
We did not have the copy, Your Lordship. We have a categorical submission in our
Wait,
paragraph.
Where?
Paragraph 9, page 14, Your Lordship.
Paragraph 9.
Of our petition. May I read, Your Lordship?
Heard Mr. T. Dury, Learned Counsel for the petitioners. Mr.
B.C. Musahari.
B.C. Musahari, Learned Standing Counsel. BTC.
BTC, Lord.
For the respondent number?
Respondent number, Lordship. 3, Lordship. 4, 6, Lordship. 3,
Six.
4, and 6.
5 is not.
5 sub-divisional officer, Gosaigaon sub-division, Lordship. ZA maybe, ZA.
Is it?
ZA.
Mr. H.K. Hazarika, Milan advocate for the respondent number 1 and 5.
5 to 5.
Mr. A. Aforesaid, learned standing counsel, Revenue Department for the respondent number 2. First one. Para. The petitioners, comma, eighteen number have stated that they are permanent inhabitants of village Habruville, part, we didn't get part, under police station Gosaigaon, Coastal. The petitioners have approached this court by the instant petition stating that a parcel of land measuring
2 bighas, Your Lordship.
2 bighas covered by dung number 2 at village Habruville was earlier reserved as village grazing reserve, PGR, Coastal. But the respondent authority is in the BTC. BTC?
Yes, Your Lordship.
After which paragraph you have said?
Paragraph number 9, Your Lordship.
9. Settled. The said PGR land by an order dated 27/12/2023 in favor of the respondent number 7, which is a cooperative society, comma, without following due procedure. First of, let notice be issued. Notice is made returnable on so-and-so. As so-and-so has appeared and accepted notice on behalf of the so-and-so. No formal notice, extra copies. The petitioners shall take steps for service of notice among the respondent number 7 by speed post within 2 working days. From today, the respondents shall ensure that their counter affidavits are filed on or before the returnable date.
1706.
Very good.
Time being matter. Item number 6.
Yes, sorry to keep you waiting. Some instructions are placed.
Yes, while your lordship has seen, in spite of prima facie making out a cognizable case, they will not register. They are more in favor of the person who has illegally dispossessed.
Will issue notice. They have made some documents. They have submitted some reports before the court also. Regarding your complaint, other cases.
Yes.
These are there.
But
medical injury report, then preliminary investigation report, all these are there.
I may furnish a copy of this. I will respond it on the next day.
Will issue notice at this stage.
Yes, sir. But only I pray that your lordship will fix a short date because
if all are state respondents, then
no,
I can.
their private respondent will take notice by justice service.
Private line.
Because that person has been released from jail and illegally dispossessed me from. Now we have filed an amended court.
Mr. B.D. Korn, senior counsel, estate by Miss H. Jain, land counsel for the petition, and Mr. N. Goswami, land junior government advocate Assam for the respondent number 1, 2, 3, 5, 6, 7, and 8.
4 will serve by justice service.
First of the Mr. Goswami, junior government advocate appearing for the aforesaid respondents, has submitted that he has received the parawise comments and the necessary instructions to file the counter affidavit and given 2 weeks' time, the counter affidavit will be filed. Post of issue notice returnable on chiefs of detail. Returnable on so and so. As Mr. Goswami has appeared accepted notice on behalf of. So and so, no formal notice is required to be issued to the said respondents. However, the conservative of petition shall furnish requisite number of extra copies of the petition along with annexer to Mr. Goswami within by tomorrow. The petitioner shall take steps for service of notice upon the respond number 4 and respond number.
By usual as well as by dusty service will be, this will be.
Respond number 4 and 4. By speed post within 2 working days from today. As short for comma dusty লিখি দিব, affidavit লিখি দিব, routed through the registry লিখি দিব. The respondent, official respondent shall ensure that its counter affidavit is filed on or before the returnable date.
10/6, 10 June. Item 7.
Yes, Mr. Choudhury.
Lordship, I have received one instruction. However, even that the e-signature is that, Lordship, the jurisdictional officer have their own individual login ID. And by getting into the portal and after giving their digital signature, then only that they can upload the documents or notices and everything. And so Lordship will find in the notices, the name and designations are given, but the e-signature that login they do it, that is regarded the system itself. That is regarded as their e-signature, Lordship.
Show me. Make me understand.
Lordship, that
Let us go
diagram.
to the impugn notices and all. Say, for example,
Lordship, page
24.
Lordship.
24.
24. Lordship, in the next page, 25. Signature is blank, but the officer issuing name is and his designation is there.
Designation is there.
Yes, Lordship. Jitan Boro, Assistant
Now,
Commissioner.
which provision requires digital signature?
Lordship, in the another rule, 26(3), everything has to be e-design, but here the system software is such that it goes in this.
That cannot be a ground when there is binding decision.
Each and every document has to be e-signed.
Binding decision already ruled, and you have
Is
not.
there, Lordship?
You have sit over it. You have not preferred any appeal.
That is not there.
Statutory rule is there. How can we a blank space? How can we?
Because by their
Just because you have
e-signature,
developed, you have not developed the software.
now, Lordship, it is modified because in the first page, that instruction that I have given, Lordship will find digitally e-signed by so and so.
That is what I have. We have already.
Now, now it
we are
has been
acting on it.
upgraded. At that point of time, this was the their Lordship.
Then consequence is same.
Yes, Lordship, invalid. It will be invalid.
It is invalid. And what is the after say declaring invalid? What is the so liberty has been given to you? If all these are held to be invalid, whether by the judgment dated 3912/2024, liberty has been given to you to initiate de novo.
Yes, Lordship. In the under
29.
F, Lordship.
F. Okay.
29.
Then let us dispose it of. Or you want to file an affidavit? Whether it will improve your case.
No, but only that the system I can explain it much more properly, Lordship, with necessary diagrams and everything, Lordship.
There is sum and substance. All these grounds would be available had there been compliance from your side.
Yes, I have said.
But all these grounds would not be available when it is a matter of recovery of revenue, when there was default on your part.
Yes, my lord.
Okay, we'll dispose it on Thursday. Then we'll go through it. That will be sufficient, I think.
Lordship, I will try to get a more detail with regard to the e-signature that I can give to the court master tomorrow, Lordship.
Okay, better. NN Jha, Learning Counsel for the petition, Mr. B. Chaudhary, Learning Standing Counsel, Finance and Taxation Department, for all the respondents. I'll list the case again on Thursday. As Mr. Chaudhary has submitted that he will place the instructions on the next day of listing. I'll keep this, the instruction placed today, further instruction in the matter on the next day of listing. The instruction placed by Mr. Chaudhary today is kept with the yes, sir.
2105.
There is no representative on behalf of the petitioner today on call when the case is called for the second time. List the case after 2 weeks, after a week, and 2 weeks by the office.
Order no steps. Item 24.
We have taken the step on 15/5/2023.
Mr. M.M. Jamal, Learned Counsel for the petitioner, submitted that steps
Yes, sir.
have been taken on behalf of the petition 15/5/2026 for service of notice upon the respondent number 2 and 5 in reference to the order dated 27/4/2026. Post stop. Peruse the office note dated 14/5/2026. Post stop. In view of the above submission made by Mr. Jamal, let the case be listed. Raised it to examine. As regards the steps taken by the petitioner, and thereafter release the case after 2 weeks with a report.
Highly obliged.
Some implead.
My lord, perhaps we'll have to withdraw, but Lord will keep the issue open, my lord. Otherwise, it will open it as a res judicata.
Okay, okay.
Because, my lord, there are subsequent judgments of the Supreme Court where Supreme Court has taken a view that in some
Has he been elected
No.
this time?
Yes.
Renew the prayer if it is permissible. That will not.
My lord, issue which we have raised there, that should be kept open.
Okay.
Otherwise, we have closure
Okay.
will operate as a constructive.
Okay. I heard Mr. K.N. Chaudhary, Learned Senior Counsel, listed by Mr. A.K. Ajat, Learned Counsel for the petition. There is a notification which is term has.
Because now, my lord,
As on
assembly has been dissolved.
it is there.
Job notification put this.
That day, I myself handed over to Mr. গৌতম
Yes, yes.
আছে নেকি এখন এখন লিখি দিলে তেনেহ'লে কামটো হৈ যাব and petitioners
Assembly to the result for
Mr. Who is for response number 1?
Yes, private response.
Private respondent, your lordship, Mr. TJ Mohanta, senior.
TJ Mo, oh, you are
I'm assisting him, your lordship.
okay, Miss
I am Barra, your lordship.
R.M. Borua, Learned Counsel for the response number 1. Mr. P. Nayak,
I'm appearing for 2, 4, and 5, Lords.
Additional Advocate General Assam for the respondent number 2, 4, and 5. Who is for speaker? Speaker, okay. Miss Ann Choudhury, Learned Counsel for the respondent number 3. Mr. A.I. Ali, Learned Standing Counsel. Election Commission of India for the respondent number 6.
7.
Huh? Okay, 8, 6, 7, and 8. Okay, full stop. Para. Inverse rate petition. Comma. Instituted under 226 of the Constitution of India. The petitioner has sought a writ of quo warranto against the respondent number 1, who was elected as a member of Legislative Assembly MLA from Ratawari within bracket SC constituency, Assam, in the Legislative Assembly election held in 2021. Full stop. The primary ground on which the writ of quo warranto was sought was that the respondent number 1 was not entitled to hold the public office of MLA from Ratawari within bracket SC constituency, as he was not an Indian citizen. Full stop. Para. By a notification dated 6/5/2000, number to likh diyo, dated 6/5/2026 and published in the Assam Gazette in issue number 191 dated 6/5/2026, the 15th Assam Legislative Assembly stood dissolved with effect from forenoon of 6/5/2026 by the Governor of Assam in exercise of powers conferred by Clause 2B of Assam Article 174 of the Constitution of India as amended up to date. Full stop. In view of the above development and dissolution of the Assam Legislative Assembly with effect from forenoon of 6/5/2026, the tenure of the respondent number 1 as Assembly Ratawari SC constituency had expired during the pendency of the petition. As a result, the subject matter of issuance of quo warranto against the respondent number 1 has been rendered infructuous in this writ petition. Full stop. Therefore, the writ petition is closed as infructuous. Full stop. However, the issue which was raised in the writ petition has remained to be adjudicated, and the question as regards the question is left open.
Yes. Just one line, Lordship, somewhere respondents have contested we are contesting the
plea of the petitioner
Hmm.
by filing one on maintainability ground and other on merit ground.
Okay.
That's fine.
They can also raise.
Just one more.
During the pendency, the respondents have also contested the writ petition. State respondent?
Yeah.
Or
He-
you are for the state only?
State Lord.
My lord.
Yes, Ms. Borua, you want to say something? Learned additional advocate general have said that the issue has been contested by the state by filing its counter. Yes. That's all.
Yes, Lord.
Question remains open.
Yes, deeply obliged.
Question is left open
Yes,
at an appropriate stage.
yes, deeply. Obliged.
Oh, IA is closed then?
Everything is fine.
Daily list for admission. Item 25.
Yes. Madam.
My lord, here the petitioners are sticking.
You were here.
Yes, I am for respondent number 10.
Respondent number.
Private response.
This is about what?
RS info. Newly implemented. Newly implemented RS info.
No, what is the case about?
My lord, here the petitioners are praying for the grant for ex gratia, my lord. Here
Ex gratia.
my lord, compensation, my lord. Here the petitioner number one husband died. You do.
Okay, madam, whether all exchange of pleading is complete.
Yes, my lord.
My affidavit is pending.
You represent respondent number 10.
10.
Who is respondent number 10?
This is RS info.
Huh?
RS info.
They are newly implemented parties, my lord.
Newly implemented.
Wide order dated.
RS Infra project.
Yes, your lord.
You are saying that electrocution date.
My lord, my lord.
Electrification.
How these
Well-
private respondents are?
My lord, here the respondent number 8 filed an affidavit stating that like the work which was issued over the company. And here the departments are.
Yeah, Mr. Sharma, you want to file an affidavit?
Yes, your lord.
Miss
T. Bapangla.
for the petitioner. Who represent whom?
Lordship, I represent respondent number 2 and 3.
R. Devi? Huh? 8. 1 and 8. 1 and 8, Miss Devi. Union of India. R. Devi, Land and Central Government Council for the respondent number 1 and 8. Mr.
R. Bora.
R. Bora.
On behalf of SP Sharma.
On behalf of Mr. SP Sharma, Land and Standing Council, APDCL. For the respondent number
2 and 3.
2 and 3. Ms. Enter N. Goswami, Learned Junior Government Advocate for the respondent number 4. Who represents 5, 6?
My lord, 5.
Sorry, N. Goswami for 7 also. 4 and 7, N. Goswami. Okay. Your name, please. For respondent number 6. Post Mr. Sharma, M. Sharma, Learned Council for the respondent number 10 has sought for and is granted how much time? 3 weeks time.
3 weeks.
To file an affidavit on opposition on behalf of the respondent number 2. So as the respondent number 2 has been
Your lordship.
subsequently implemented as a party respondent, the prayer is allowed.
Your lordship, respondent number 10.
10. Please the case on the bench.
1506.
Okay.
Item number 26.
May I please, Your Lordship? Lordship, petitioner's NGO was recognized as specialized adoption agency, my lord, under section 41, subsection 1.
Gautam Roy Fence
Fence
Club.
Club, my lord.
Wow, Fence Club.
Yes, my lord.
How many members it has?
Lordship, there are so many members, my lord.
Gautam Roy Fence Club. But you don't have any address.
Lordship,
You don't have any address.
address, my lord,
Your cost title does not indicate any address.
yes, my lord,
Right.
number two, petitioner number two, my lord.
But your writ petition does not also indicate an address. And who is this man, petitioner number two?
Two is the chairman, my lord, of this NGO, my lord.
Where from? Is it a registered society?
Yes, my lord, registered society.
Where is the certificate?
Under society registration act.
Where is the certificate, sir?
Certificate is not annexed, my lord.
Certificate is not annexed.
Annexed, my lord. I have the.
Fan club registration, society registration, repair, whether it has a validity.
Yes, my lord. It was valid.
Where from? Are you renewing the validity?
Yes, my lord. It was valid on 16/6/2025, and later on it was renewal was also done, my lord.
But you don't have any address. Where is your earlier certificate?
Certificate is, my lord.
No, juvenile justice act now.
Address of the Friends Club is, my lord, Lala Town, Ward number 9, Lala Hailakandi, my lord.
So you completely failed. Page annexure 8.
Lordship,
24.
kindly say, my lord, act, my lord, definition of specialized adoption agency, my lord. Section
Single
257, my
beneficiary,
lord.
not a single beneficiary.
Lordship,
Then the office
section
emperor-
57, subsection 57 may be seen, my lord. Child Welfare Committee is the competent authority to provide children, my lord.
And
I am not the
it will be
competent authority, my lord. And they
in November, you
provide the child, my lord.
cancel. Cancel. When it was cancelled?
Cancel
17.
17, my lord.
15/5.
The page, page,
24.
page 24.
24.
24. Now what is your ground?
Lordship,
Which section?
section 2, subsection 57, my lord, of Juvenile Justice Care and Protection of Children Act 2015, my lord.
57.
Section 2, subsection 57, my lord. Specialized Adoption Agency means an
What is the main rule? What is the act?
act, my lord.
Juvenile Justice Act?
Yes.
2015.
Section 2, subsection 57, my lord.
Section 2.
Subsection 57. my lord.
Okay, 57. Section 2. 57.
Specialized Adoption Agency, my lord, means an institution established by the state government or by a voluntary or non-government organization and recognized under Section 65 for housing orphans, abandoned and surrendered children placed there by order of the committee for the purpose of adoption. I am not responsible to adoption of the children, my lord. Child welfare.
Where is
committee
the
is
certificate first? Recognition. Member Secretary, State Child Protection Society. Where is your first recognition?
recognition, my lord. Page, my lord.
15.
Page 15, my lord. Certificate of recognition of specialized adoption.
Adoption agency. Established by the state government or voluntary, recognized under 65. Let us see 65. Where they have an order of the committee. Let us see section 65. 64. What is authority? Section 65, subsection
65,
1.
lord, subsection 1.
What is this authority?
Rehabilitation.
Adoption regulation. Who is the adoption regulation?
This is
Adoption
the-
regulation 2022. But your adoption regulation was 2016. Adoption regulation. Adoption regulation. National Charter. Background. Adoption regulation. Where is that adoption regulation? Adoption regulation 266. 266. Authority.
Page 45, my lord. This book, my lord.
No, you see a section. Your book and my book are not comparable.
Section 65, my lord.
65, I have seen. 65, subsection 1.
1, my lord.
Who is that authority?
Specialized adoption agencies, my lord. State government shall recognize or more institutions or organization in each district as a specialized adoption agency.
So your PS 15 is not issued by state government.
Lordship.
Your PS 15 recognition itself is not issued by state
Lordship,
government. One or more institution or organization in each
There
district as a specialized adoption agency. in such manner as may be provided in the adoption regulation framed by the authority. Then some state authority recognition. To inform you that the government is recognized so function as so adhere to the guidelines of governing adoption regulation. Where is the relevant adoption regulation at that point of time? What is the relevant adoption regulation?
Adoption regulation, my lord.
You have to place it. Then only we can proceed further. Now it is adoption regulation 2022. At an earlier point of time, it was adoption regulation 2017. But at your time when you were recognized, that was something else, adoption regulation.
My lord, it was 16, my lord.
Place it the relevant adoption regulation, which was in force at the relevant point of time, right? And the respondents, yes, do you have any?
Regulation 16, my lord.
Where is that? I heard Mr. H.L. Oscar Learned Counsel for the petitioner.
Rule
And
19,
Mr. N.
23.
Sami Learned. Junior some for the respondent number.
I am
1, 2,
3.
1, 2, and 3. What kind of instruction you were asked on 15/12/2025?
15 to submit the renewal certificate, my lord.
Place the adoption regulation, Mr.
Adoption regulation, this
By way of an additional affidavit, then only you can proceed.
in this book, my lord.
That was of 2022 I have. I do not want to buy that book.
Yes, Lordship,
This book has only 2022 regulation,
Lordship,
which had repealed 2017 adoption regulation. And you were recognized in 2016. So what was the adoption regulation at that point of time?
Lordship.
You have to bring on record because you were born by that regulation.
Lordship.
Mr. Loskor, Learned Counsel for the petitioner, has sought for and is granted 2 weeks' time to bring on record the relevant adoption regulation, of which was in vogue at that time when the petitioner was recognized as a specialized adoption agency. The President lays the case on students.
5th June, 5/6.
You can take back this. You can bring it on record by the additional
By an additional level.
Items 27 and 28.
Lordship, in this particular case, though I have to file a civil suit, because the interim order was passed not to release the fund in favor of the respondent, I have completed the work in all respect. Thereafter, Lordship, the executive engineer, without my knowledge, one order issued, work order has been given to another person, to private respondent 5 and 6. That is why I have challenged this order, and that's for interim order. This court ordered that not to release the fund in favor of the private respondent 5 and 6. But after having the order, after communicating the order, they have released the amount. Thereafter, Lordship, we have filed a contempt case. In the contempt case, and they have filed an affidavit that the copy was received by the assistant of the office, executive engineer office. He has kept the file in the drawer, and thereafter, Lordship, she has left because of his child illness, and that is why he was not aware. Actually, I have filed an affidavit reply to that effect that I have communicated the order to the office head assistant as well as to the executive engineer itself. And they informed me to give the copy to him. And thereafter, Lordship, they paid them.
Whether Mr. Upadhyay has filed an additional affidavit.
Also.
Lordship, before that, Lordship, the BTC has also filed an affidavit, Lordship, whereby they have stated that whatever amount pays to the petitioner, it has been paid. But I am not on that, Lordship, because I am in contempt. But Lordship, whatever is payable to him, that has been paid to the petitioner, Lordship, as per the affidavit of the BTC, Lordship.
Which affidavit? When?
Lordship, the
Main case also.
main case, Lordship.
I am appearing in main case, Lordship.
Recent affidavit or what?
At page 160, Lordship, paragraph number 11, Lordship.
160.
16.
What amount he had received?
Whatever the petitioner has executed.
No, you don't indicate. Have you indicated?
Yes, Lordship.
The amount
That
has
he
been-
received the full amount of the work executed by.
70% he petitioner has executed and
You must have a figure.
According to.
figure also given. Figure also given.
As what, 17,64,000? Yes, Mr. Usami?
Figure given, Lordship. Annexure number B, Lordship. 160.
Annexure number?
B, Lordship. B.
166 page number.
166, Lordship. 166, 167 and 168. Lordship. 80 lakhs, 82,000.
80 lakh.
80 lakhs, 82,000.
Revised work order. Revised work order in favor of another person.
Another person.
Private respondent.
And he was paid 32 lakh. According to you, you had completed the work.
Completion certificate issued by the executive engineer itself. 100% completion.
For the amount of rupees, so and so. Mean receipt.
And same executive engineer was arrested of some false allegations or false payments.
And executive engineer, not this.
Not this, that person who has done this.
Yes, yes.
Irrelevant.
This 166 indicates work order amount is 90 lakh something. And you were paid 80 lakh.
Okay.
About 19 lakh deficiency. You submitted bill to the extent of 80 lakh only.
No.
According to this, see this gross bill amount, you have submitted 3 bills. Gross bill amount is this, 80 lakh, 83,649. And amount paid, according to the 80 lakh, 82,000. So it is about 1,000. Out of the gross bill amount, you did not receive.
According to them.
According to them, and they have given the bill also, 1 to 3. And so far as revised work order in favor of some other contractor,
Yes, sir.
26.
he raised bill to the extent of rupees 32 lakh. He was paid 32 lakh something, more than the submitted bills. He raised bill for 32 lakh 50,262 and he was paid 32 lakh 51,000 something, more than what he had submitted. But so far as you have received 1,000 less than what you had submitted.
Nothing remains, Lordship, in this.
No, just I'm trying to understand. So have you controverted this fact?
No.
Not filed, counter affidavit not filed.
Because controversy remains for 1,000. First, no, just I'm trying to understand. I'm not reaching any view. Controversy as per this table, you had received 1,000 less than your bill value.
Lordship.
So, as per this document, your grievance would be to the limited to 1,000. 1,000. And secondly, that other allegation that this other respondent had been arbitrarily and illegally given the contract work. Had he snatched anything from you other than illegal award by deemed termination of your contract? Had he snatched anything from you?
Only thing is, Lordship, my challenge was in this particular case. I have been allotted the work. I have completed the work. Running bills were paid. I have given a certificate by the executive engineer, countersigned by the assistant engineer, that I have completed 100% of the work.
What is the total?
Total work order I have annexed, Lordship.
What is the total?
Total work order was
contract value you had executed.
Lordship. Total work order, Lordship will find.
No, work order could be different, but the total amount contract value you had executed.
Lordship.
Work order could be different. They have said work order was 99,43,000. Where is your work order?
Lordship will find at page 28 of the petition.
28. What is the total work order value? 99,43,185. That is reflected in the in page 166. Same. That is reflected. Now, how much you had completed?
100%.
No. Where is the completion certificate?
You will find page 65 of the petition. Lordship will find page 66.
Mm, 100%. Any in the completion certificate, we find normally the value of the work order executed.
Nothing has been stated, only that what has been completed up to the progress 100%.
That I have seen.
Thereafter, work order has not been cancelled in favor of me, granted by the authority, and fresh tender has been issued behind my back, and work order has been issued in respect of the same work to respondent note 5 and 6. Then 5 and 6 has not contested the case. Notice was served to him, and there is a stay order from this honorable court not to release the fund, but they have released the fund immediately. Mainly, petition will become infractions because they have to file a civil suit for recovery of the amount. But in the contempt case, how they have released the amount, between the court and the lordship, the contemptor. Order dated 27/5/2022.
Just a minute.
Page 15, lordship.
Just a minute.
চিঠি দেখো
Forcefully quoi? Forcefully quoi?
Yes, Mr. Upadhyay. You have tried to explain the subsequent events, saying that you have not taken any action against Anari Boro.
Lordship. Page 43, Lordship, paragraph 3, we have taken the stand, Lordship, and in fact, the fact remains, Lordship, that the petitioner was
Sin Bormon. Sadhan Bormon.
Lordship.
I don't know by what manner this Southern Bormon had made the junior assistant to owe the responsibility.
That stand has been taken also on earlier affidavit also. I have given the reply that I have given the copy to the executive engineer, head assistant, as well as to the council head. But they have said that it was given to assistant. I have given a reply to that effect also. Same stand has been taken. Only thing is they have taken that their own departmental proceeding action has been taken against the RO.
For the petition is concerned, there is disputed question of fact is there, Lordship. So, but contempt case, Lordship, I seek apology, Lordship.
But everything has been done by another executive engineer, but I could not brought him on record because he has already retired from service. Everything has been done by another executive engineer against whom criminal cases were filed.
But here we are Sadhan Burman.
Yes, sir.
Soitya was the person, but he has retired from service. That is why I could not bring him record. And Soitya has done everything.
But Soitya Kolita, no, where is the order of non-compliance? 27.5.
That time he was there.
But who has filed this subsequent affidavit in opposition?
Affidavit has been filed by, let's say, the Sadhan Burman.
Sadhan Burman.
Because
he was the executive engineer at the relevant time.
yes.
Subsequently.
No, order was when? Court order was 27/5/2022.
That's it.
Right?
That's it.
And till the returnable date, that is 27/6/2022, no payments shall be made. That is the order.
No payments shall be released.
To respond number
6 and 7.
6 and 7. And you allege that that payment was released in favor of respond number 6 and 7. You brought that order to the knowledge when?
I have made a specific statement. Let's
No,
reply.
date. 35/2022. Page 17.
That's it. It was received on 1/6/2022.
And to the executive engineer?
To the executive engineer, Lordship will find. On 2/6/2022.
Huh?
On 2/6/2022, page 35.
Page 35.
That's it.
Twenty-seven 5/2022. 2/6.
Page 41 is the acknowledgement by the office of the executive engineer.
Page?
Page 41.
2/6. On that day, who was in charge?
Sadhan Burman, sir.
Sadhan Burman.
But Lordship, as I have stated, Lordship, the copy was not placed before the concerning executive engineer, Lordship. And he was unaware of the court's order, Lordship. This is my stand, Lordship. There is no.
This was seal and signature by Illa, you said?
Probably, Lordship, this.
Illa.
Anari Boro, probably.
No. Yes, seal and signature was there. Pongla received. Whose signature is this? Any idea?
Head assistant.
Huh?
Head assistant.
Head assistant. Ila Doimari.
Ila Doimari.
And what that lady Anari Boro said?
Anari Boro, according to him, Anari Boro
without noticing if there was any letter left. So she said she did not notice it.
Lordship.
Both 39, 40. Then thereafter, when the notice was served, 27/6.
27/6, Lordship.
After the returnable date. That was the returnable date. Sadhan Burma. I did an official letter. Then reply. Then when he got transferred?
Lordship, in 24, he got transferred, Lordship. In additional affidavit, I've stated, Lordship. Subsequently, he retired from service, Lordship.
When the first affidavit was filed?
First affidavit was filed, Lordship. It was filed in the month.
17 April 2025.
Yes, Lordship.
21st August 2023. Unconditional apology.
Lordship.
Retired. Maybe benefit of doubt. Illa Domari, and he has somehow he has managed to put the buck to Anari Boro, who had replied admitting all. Maybe forceful, and we cannot say now. Let him give the benefit of doubt, Mr. Goswami. What do you say?
And liberty may be going to file a civil suit, Lordship, because we have
heard Mr. In a contempt petition. Heard Mr. S.K. Goswami, learned counsel for the petition, and Mr. N. Upadhyay, learned counsel for the respondent.
In the main case, Lordship, I am for the respondent number.
I am passing the order here.
Lordship.
First,
Lordship.
First off, this contempt petition was preferred, alleging non-compliance and willful disobedience of a direction made in an order dated 27/5/2022, passed in a writ petition WPC number 3522/2022. Post office. The petitioner instituted the writ petition, stating inter alia that he was awarded a contract work wide and work order dated 8/3/2013
and 12/3/2013
8/3/2013
and 12/3/2013, 2 works.
And a contract work in the year 2013 for a contract work AHU pays 28%. Band FIS so and so at a contract value of rupees 99,43,185 approx by the Office of the CHD within bracket irrigation BTC and Superintending Engineer Kokrajar Circle Irrigation Kokrajar. Stop. It is the case of the petitioner that on being awarded the said contract work, he had proceeded to execute the same two contract works. While work orders dated 8/3/2020, 2013 and 12/3/2013. But this had happened for what? Which one?
Lordship.
This illegality had happened in which contract work?
Both.
Both,
Lordship. Passage number 5 and 6. 5 has been allotted to one work and 6 has been allotted another.
Okay. On being awarded the contract work, he proceeded to execute the same, and according to him, he executed the two contract works to the extent of 100%. And completion certificates were also issued to that effect by the concerned authorities. Post of yet, the respondent, one of the then, so sorry, but the executive engineer, Paneri Kolaigaon Division, within bracket irrigation, Tongla, by showing that a part of the two contract works were allotted to the two other contractors had issued work orders allotting a part each from the state to contract works already awarded to the petition. Post of it was in the above background, the petitioner instituted a writ petition WPC number 3522/2022. Post of when the writ petition was moved on 27/5/2022, the court, while issuing notice making it returnable on 27/6/2022, had observed in the interim that till the returnable date, that is 27/6/2022, no payment was to be released in favor of the two contract works who were shown to have been awarded a part each of the two contract works already awarded to the petitioner. Post of para. When the petitioner, so after the order, a copy each, a copy of the order dated 27/5/2022 was brought to the knowledge of the respondent number 2, party respondent number 225 in the petition WPC number 3522/2024-22. Insofar as the respondent number 6 is concerned, the order dated 27/5/2022 was brought to the knowledge of the said respondent on 2/6/2022. Post of the petitioner has came to learn that prior to 27/6/2022, a substantial amounts were released to the said two contractors, namely Pradeep Boro and Niran Chandra Boro. Post of alleging non-compliance of the and willful disobedience of the interim direction made in the order dated 27/5/2022, the instant contempt petition was preferred. Post of the sole respondent was put to notice on 2/9/2022, and after entering appearance, an affidavit was filed by the respondent on 21/8/2023. Post of in the said affidavit, it was canvassed that though the order dated 27/5/2022 was communicated to his office on 6/6/2022. He was not aware of the said order till 27/6/2022. And in the meantime, payments were released in favor of the said two contractors. Subsequently, on inquiry, he came to know that the order dated 27/5/2022 was passed. The copy of the order dated 27/5/2022, submitted by the petition, was received by one Srimati Anari Boro, Junior Assistant Paneri Kolaigaon Division Irrigation Tongla, on 6/6/2022. But instead of bringing it to the notice to his notice, kept the order in file number ER/1, and the said fact was not also in the knowledge of the head assistant of the division. It was further averred that on immediately after coming to know about the fact that the order dated 27/5/2022 was brought to his knowledge by Srimati Anari Boro. Was received by Srimati Anari Boro, Junior Assistant, on 6/6/2026, a so-called notice was issued to him, to Anari Boro, on 27/6/2022, asking her to show cause as to why disciplinary action shall not be taken, shall not be initiated against her for her responsible act of not bringing the order dated 27/5/2022 to the notice of to his notice or to the head assistant of the division immediately after the copy was received by her. A reply to the so-called notice was submitted by Srimati Anari Boro on 1/7/2022, wherein she had admitted her failure to bring the order dated 27/5/2022 to the notice of either the petition respondent or the head assistant of the division. And in the reply, Srimati Anari Boro had further admitted that due to the inadvertence, the letter by which the petitioner has submitted the copy of the order dated 27/5/2022 was kept inside the file. The reason attributed for such failure on her part was illness to her son of about 4 years and 5 months. This court on 10/2/2026 noticing that though an inquiry was sought to be initiated against the junior assistant, though an inquiry was sought to be initiated by the respondent against the junior assistant as regards her delinquency, but no by issuance of the so-called notice on 27/6/2022 and and finding the further steps taken after submission of finding that the affidavit was silent as regards the further steps taken after submission of the reply by the junior assistant on 27/6/2022, directed the respondent for filing of an additional affidavit addressing on the aspects regarding the steps taken for recovery of the to demonstrate that the proceeding initiated by the so-called notice dated 27/6/2022 was brought to a logical conclusion. Full stop. Subsequently on ten 5/5/2026, the respondent has filed another affidavit stating inter alia that after receipt of the so-called reply dated 1/7/2022 from the junior assistants to the so-called notice, he, upon careful consideration of the same and the materials on record, found that the lapse occurred due to exceptional and unavoidable personal circumstances attributable to the junior assistant, as the concern and as she had to urgently attend her minor son, who was suffering from serious illness and required immediate medical attention. Post up. The respondent was of the view that the act of the concerned junior assistant was neither willful nor mala fide, but occurred due to bona fide reasons beyond her control, and in good faith and in exercise of unprecedented discretion, he did not initiate any further departmental or penal proceedings against the junior assistant, considering the explanation to be genuine and satisfactory. Full stop. Be that as it may, the respondent has tendered his unconditional apology due to any omission or commission on his part in implementation of the interim direction made by the court in the order dated 27/5/2022. Full stop. Para. The respondent has already retired from service on reaching the age of superannuation on 31/10/2025. Full stop. Para, taking the unconditional apology tendered by the respondents into consideration, and the fact that the respondent has already retired from service on reaching the age of superannuation, any act in non-compliance of the interim direction made in the order dated and in view of the projection made in view of the statements made and averments in the two affidavits, it is not possible to reach a definite conclusion that there was any mala fide act on the part of the respondent to willfully disobey the interim direction dated 27/5/2022, the contempt petition. This court is of the view that no proceeding, no initiation of any contempt proceeding is not called for in the factual circumstances of the case, and therefore the contempt petition is closed. Any prolonged observation is required to be made in the petition.
I have to buy the civil suit, limitation will
প্ৰথম ফেক্স খিনি লিখি দিব হা প্ৰথম ফেক্স খিনি যে তাতে পিটিশনাৰ কৰি দিব হাৰ্ড মিষ্টাৰ এছ.কে. গোস্বামী and counsel for the petitioner Mr. N. Upadhyay, Standing Counsel Irrigation Department for the respondent number
1 and 2.
1 and 2, and Mr.
B.C. Musahari.
B.C. Musari, learned counsel, standing counsel for the respondent number 3, 4,
3, 4, 5.
5. Post of. তাৰপিছত সেই work orders খিনি date খিনি লিখি দিব a allegation regarding to private hearing লিখিব. The petitioner has contended that he had, after being awarded the two contract works having contract value of rupees 99,43,185 and rupees 65,43,662 respectively, and he had executed the said two contract works to the extent of 100% to the satisfaction of the concerned authorities. So on the other hand, the respondent authorities have sought to dispute, and therefore he is entitled to receive the entire amount of so and so and so and so against the said two contract works, and till date, the entire amount has not yet been disbursed in his favor. So on the other hand, the respondent authorities have disputed such assertion of the made by the petitioner by projecting that the due amounts the amounts due to the petitioner for the works executed by him in respect of the said two contractors have already been disbursed to him, and no other amount is due to him. In view of such contrary projections made by the parties, the claim, the relief sought by the petition in the instant petition seeking inter alia a direction to release the final payment for the works allotted and completed by him as per the work order dated 8/3/2013 and 12/3/2013 for the works under the AHU Band FIS Scheme 2013 cannot be adjudicated as a number of disputed questions of fact are required to be determined, which can be possible only in a full-fledged trial where the parties are required to lead evidence, oral as well as documentary. In such view of the matter, this petition is closed, reserving the liberty to the petitioner to avail appropriate remedy if the petitioner is still aggrieved by non-release of any amount in terms of, in respect of the two contract works awarded to him by the work order dated so and so and so and so, as permissible under the law.
Obliged.
Mas.
Item 29.
Yes.
Should we kindly peruse the order that 23/3/2026, madam?
Lordship. So I, we have some time, Lordship, my lord, that our affidavit, we have stated that, my lord, it, remark, my lord, that, my lord, it cannot be done due to the water logging of that time.
It is still rainy season.
No, on that time, Lordship.
That affidavit was
After
filed
Now also.
That affidavit was filed in the month of September 2025. Thereafter,
After that,
they were
my lord-
sitting about the matter, madam.
After that, my lord, the matter was
No doubt it is still rainy.
27.
We put it on after 1 month. Maybe dry season will come. What do you say? You are saying that road could not be measured during, could be measured only in the dry season. So what to do?
So let me take instruction regarding that. We have filed my affidavit in the month of September.
Heard
2025.
Mr. I. Soike, learning counsel for the petitioner, and Mr. J. Hendrik, learned junior government advocate for the respondent number.
So we are not made a party, my lord. Only the honorable courts were directed to me.
Who is for PWD? Mr. D. Nath, learned standing counsel PWD for all the respondents. Mr. J. Hendrik, learned junior government advocate. Where from the circle officer came then? He has filed an affidavit.
Lordship, we have filed an affidavit only the honorable court.
Oh, you are not a party.
Lordship.
The PWD has requested the circle officer for a demarcation. Honorable court has directed the circle officer to have the instruction why the demarcation was not done. In that situation, circle officer came.
What happened, my lord? On my patta land, my lord, PWD is constructing a road, my lord, without acquiring the land.
No, it is a existing road, my lord. Only improvement work was started. At that stage, my lord, they came. Otherwise, photographs are there. Before your lordship, photographs are there. It is an existing road.
Let circle officer decide.
Lordship.
But file an amended cost cycle, otherwise it will be difficult. That is to instruct Mr. Hendrik to obtain instruction every time. Make him a party so that we can direct him instead of requesting him.
I will file an implementing petition. I will file an implementing petition.
File the amended cost cycle. As it is noticed that circle officer, the circle officer Borkhetri Revenue Circle is a necessary party in the instant repetition. Mr. Soikia, learned counsel for the petition, has sought a week's time to file an amended cost cycle to make the circle officer so-and-so as a party respondent number 4. Release the case on so-and-so, or packing likhi dibo after finding so-and-so. Correction kori dibo, release the case on next week.
Item 30.
May I please, your lordship?
It is that one.
Yes, lordship. Instruction was what?
Not possible to be disposed of, but that is for inquiry.
No, I'll not say that. The lordship has asked me to go through the judgment of Honorable Justice Yubhia. I have gone through. So, as per that judgment, my lord, WPC 2100/2019, ex gratia is an amount given by the state out of gratitude, which has which is in addition to amount payable under the statute, that is MBA. That is not being considered while passing Manisha. That is correct. So
So
here
that,
in this case, madam, it's a vehicle is not identified. Then he's
not possible to dispose of
Yes.
now. But
Yes.
I remember that it
Yes.
is in addition to.
yes,
And if that is not considered by the subsequent judgment,
yes,
law says that it will be per inquiry. And it was the duty of the council also.
we missed.
Yes, you missed. SI account. But please produce those two judgments.
Yes, madam.
আছে না judgment? File to my to দিব। File to my to দিব। Okay, কোনে কমছে দি দিওক। SI account, aforesaid, and to file. List the case on so.
1st June.
It this
1/6.
is Gunalata. What is the other one? What is the other one?
Monisha Khatun 27.
Wait a minute. We'll dispose of last time. So.
Item 32.
On last occasion, the deputy commissioner was made a party respondent number 8. So today I'll submit them a copy, madam.
We'll issue notice then. If has notice been issued?
Yes, notice.
No.
Notice. Not to the DC, madam. Not to the
DC.
Not to the
Now he'll accept notice.
Yes, madam.
Miss Sharma is for what?
For the health.
Health. And Miss
I'm appealing for the respondent number 7, Your Lordship. Private respondent.
SP does petitioners.
I have a humble prayer. If you
Petitioners. Any CGC, respondent number 1? Who is for respondent number 2? Please show your numbers, huh? Miss S. Sharma, Lanet, Standing Council Health and Family Welfare Department for the respondent number 3, 4, and 6. Who is for 5? State Legal Service Authority.
They have filed their affidavit also. Rakesh.
Miss. Not present, will not record. Mr. You are Miss.
Yes, Bhuya, Your Lordship.
Yes, we on behalf of
Respondent number 7, Your Lordship.
Learned Council for the respondent number 7. Okay. Let notice be issued to the newly impleted respondent number 8. So the notice is made returnable on so and so. Date after 3 weeks did you go or 2 weeks did you go? Lease the case on sense as Mr. PK Medi, Illinois Junior Government Advocate, has appeared and accepted notice on behalf of the respondent number 8. Issuance of formal notice is dispensed with. However, a copy of the petition along with annexure is to be served upon the respondent number 8, Mr. Medi, within by tomorrow. So what is the issue about?
My issue is the petitioner number 1 is the father of petitioner number 2. Petitioner number 2 is bedridden now, presently.
2 is?
Bedridden, madam. With a brain stroke. And number 7, my private petitioner number 7, she is my wife of the petitioner number 2. She has filed a divorce case against me on different grounds. So, madam, since I am bedridden, I have paid before this.
Who is bedridden? Petition number 1 or petition number 2?
Petition number 2.
2.
Yes, petitioner number 2 is my husband, Your Lordship, and I have filed a divorce case.
2 is husband.
Yes. Of
Petition number 2 is husband.
Yes, Your Lordship.
So, madam, petitioner number 1 has petitioner number 1 being the father. He has filed an application to issue a limited guardianship certificate so that he can contest the case, madam.
Okay.
I have a humble prayer, Your Lordship. On the last occasion, that is on 1st of April, Your Lordship, we have made.
With what prayer this petition has been filed seeking dissolution?
Your Lordship, the divorce was.
You are the petitioner.
Yes, I
In
am
a
the
divorce
petitioner in the divorce case, Your Lordship. So on the last occasion, on 1st of April, we have made a prayer before this honorable court for Sunday's matter for mediation. As this writ is arising out of a matrimonial dispute, Your Lordship, there is scope of reconciliation. So,
My to their I have no instruction, my lord.
But here we are concerned with the writ petition where limited guardianship issue.
yes,
If
but
you both agree, but it has to be raised in the
Yes, my lord, not here.
family
But
court.
here the
we
issue is,
went there. As the matter was stayed by this honorable court, no petition, nothing has been accepted by the honorable principal judge, Your Lordship, family court. That is the main issue.
27-6, madam.
The interim order passed here shall continue till the next date of this thing. First look. As you are ready.
But not, I have no instruction.
Mediation what?
But I have no
It is not forceful.
Let me take the instruction, madam. Put that.
Because the 1st of April,
It is not forceful.
But I'll take the instruction, madam.
It is only on
I'll call her, madam, over phone, madam.
Okay. List and that seems.
8-6.
obliged Lordship.
Item 32.
33.
Yes.
In this matter, my lord, necessary forwarding has been made on the part of this in respect of petitioner number 1. So far as petitioner number 2 and 3 is concerned, my lord, necessary documents and photographs are required, I am told, my lord. As and when this will be provided, within a week, they will also forward, my lord. For the other two petitioners.
Hard Mr.
SK Chakma.
S.
SK. Sunil
S.
Kumar.
S.
SK Chakma.
S.K. Chakma.
Yes, Your Lordship.
Petitioners. Miss M. Formal, Junior Government Advocate Assam for the respondent 2 and 6, and Miss S. Sharma, Standing Council Family Health and Family Welfare Department for the respondent number 3 and 4. Mr. P.K. Medhi, you are Central Government Council?
Yes.
Mr. P.K. Medhi, Central Government Council for the respondent number 1.
State or
Any finance? Where? The petition, all the 3 petitioners have claimed that have stated that they are acid attack victims. Full stop. On by circular bearing number so and so, এটা order আছে মোৰ আগৰ 7/2/2025 by a circular bearing number 24013 of the Ministry of Home Affairs, Government of India, dated 9/11/2026, addressed to the Chief Secretaries of all the state governments. It is in a circular. It is mentioned that the Government of India has also taken a decision to provide additional financial assistance of rupees 1 lakh, within bracket, over and above the amount provided under the Victim Compensation Scheme, bracket close, to the victims of acid attacks, para. On a query made by made to Miss Bormon, comma, it is submitted that the documents regarding the relevant documents to seek the additional compensation of rupees 1 lakh on behalf of the petition number 1 have been received. Full stop. But till date, the relevant documents
As well as photographs.
and photographs pertaining to the petition number 2
Two and
and the petition number 3 to submit proposals on their behalf from the office of the district commissioner, Kamrup Metro, are not yet received. Full stop. If the petitioner, said to petitioners, submit such relevant documents along with photographs within a period of time, short period of time, their proposals can also be forwarded from the office of the district commissioner, Kamrup Metro, to the Ministry of Home Affairs for the additional
Ex gratia.
additional, what is the term? Additional financial assistance of rupees 1 lakh. In response, Mr. Chakma has submitted that the relevant documents pertaining to the, along with photographs pertaining to the petition number 2 and the petition of 3 can be submitted within a period of 2 weeks from today.
2 weeks.
Full stop. Let the case be placed, listed after 3 weeks on so and so for further consideration.
My instruction may be kept as.
The instructions placed by Ms. Borman today are kept with the case papers, the papers will are kept with the case.
1506.
Lordship, in this case, CGC for CGC, I mean.
SS Roy.
15 June.
Obliged.
Item 34.
Lordship, here I pray for some time to bring the instructions.
As Dr. Petitioner is present, huh? Mr. SS Roy and Junior Government Advocate or CGC.
No, it's state lordship, 3 and 4.
Let's Junior Government Advocate appearing for the respondent number 3 and 4
3 and
has
4.
sought for.
3
It
weeks.
is granted how much time?
3 weeks, Lordship.
3 weeks time to obtain essay instruction and to file the counter affidavit. This is the case on Swens.
Obliged.
Item 39.
May I please, my lord?
Hmm.
My lord, today I have been served the copy, my lord.
Okay.
For weeks.
A.H.M.R. Chori Learned Counsel for the petitioner. Mr.
K. Vishwakarma, my lord.
K. Vishwakarma Learned Counsel
Respondent number 3 to 6.
3 to 6. Mr. S. Dr. Learned Senior Counsel. Essay by Ms. S. Musari Learned Counsel for the respondent number 2. Yes, that's Roy Learned Junior Government Central Government Council for the respondent number 1 are present. Mr. Vishwakarma has sought for and is granted
4 weeks time.
4 weeks time to obtain essay instruction and to file the counter affidavit on behalf of the respondent number 3 to 6.
I request my learned friend. The lordship will find page 25 not eligible account.
Page?
Page 22 to 25.
Okay, Mr. Chori Learned Counsel for the petitioner shall furnish legible copies of Annexer 2 to the writ petition to the respective counsel of the respondents within 2 working days from today.
They should be careful because the lordship cannot read anything from you.
That 4 copies, my lord, legible, but so far.
Here it is legible.
For us, you don't.
Oh,
No, no, my lord,
yes.
In fact, my lord, the
Yes.
copy is same is
And
my.
that is all the respective councils.
I'm obliged, my lord.
Anything more? It is already over. Okay, Diop. Diop, 40.
Item number 40.
Yes, Mr. Deka.
Lordship, respondent was supposed to file a.
As Deka, learned counsel for the petitioner.
May I please your lordship, we are on behalf of the Assam State Housing Board. We have just been informed that we'll be appearing for this case, so we need to file the wakalatnama and
And Mr. H.K. Hazarika, learned junior government advocate Assam for the respondent number 1 are present. Miss
R. Bhargav.
R. Bhargav, learned counsel has submitted that she has instruction to appear on behalf of the respondent number 2 and 3. And wakalatnama would be filed within a short period of time. So within a short period of time. And you want to file affidavit also?
Yes, your lordship.
Ms. Bhargav has also sought for 4 weeks' time to file a counter affidavit on behalf of the said respondents. So the prayer made on behalf of the respondent number 2 and 3 is accepted. Release the case on so the interim of the past status will continue till the next date of listing. It is further observed that the pendency of the petition shall not be a bar for consideration and disposal of the appeal in accordance with law. 42 there, 42 the same thing.
For orders.
40.
Item 42.
Item number 42.
গগৈ না এইটো গগৈ থাকিব লাগিব তেতিয়া হ'ব নহ'লে নহ'ব এইটো বেলেগ এইটো দি দিওঁ The name of Mr. B. Gogoi. List the case on so the name of Mr. B. Gogoi, learned additional advocate general Assam is to be reflected in the cause list.
2905.
And side in the cause list. Diop, 44 to Diop.
Item 44.
Dismiss for default, my lord. There is a delay, my lord, so notice
Okay.
may go.
Dismiss for default notice is to be issued.
Yes, my lord. For condonation of delay, there is 219
You
days.
again, you were almost on the verge of dismiss for
I'm
default.
sorry, my lord, I missed the item.
Otherwise, I would have dismissed again.
Another set of counsel was there, my lord.
Okay, heard Mr. H. Das, learned counsel for the petition. First of this interlocutory application is preferred seeking condonation of delay of 219 days in filing the accompanying application under section 5 of the limitation. In preferring the accompanying Ms. case seeking restoration, post of issue notice returnable on so Mr. Roy for opposite party number 1 CGC. HK Hazarika 4 5 6 7 A Bhattacharji for 1 A Bhattacharji for OP 3 Baki 2 8 9 and 10 11 12 লিখি দিব issue notice returnable so সব আগে লিখি দিব steps speed post
1206. Item 45.
May it please your lordship. Lordship, as per office note dated 14/5/26, AD card and neither the unserviced notice has been received back, your lord.
Mr. N.S. Mazharbhai.
I.S. Mazharbhai.
I.S. Mazharbhai and counsel for the petition is present. First of in view of the office note dated 4/5/2026, let the case be placed before the Lajima court as regards a report of as regards a report of service on report of service upon the respondent number 4 and how much any other no and they have to list the case on so and so
86. Item 46.
same about
Your lordship.
I.S. Mazharbhai. How many? 4
3 private respondent.
Four, five, six. Okay. Let the case be placed before in view of the office note dated 14/5/2026, let the case be placed for before the Ranjima Court to ascertain as regards service of notice upon the respondent number 4, 5, and 6 by way of dusty. First of await for the service reports in respect of the notices sent to the respondent number 5, 6, and 7 by speed post. Oh, unserved notice. 5, 6, and 7.
Lordship, 5 was served, only 6 and 7 was unserved.
No, regarding not dusty.
Okay.
Regarding speed post.
Speed post.
Okay, report back in speed post of they have to release the case. They have to release the case on service.
86.
Obliged, your Lordship.
Item 47.
May I please, your Lordship? Lordship, in this matter, respondent number 8 and 9, we have taken the steps, your Lordship. As per office note.
Yes, what to do?
8 and 9 is appearing, your Lordship, my friend.
Lordship, I'm.
8 and 9.
Yes, Lordship, need to file the affidavit.
You have
Wakalat
appeared.
nama, Lordship.
Mr.
R. A. Mazumdar.
R.
A. Mazumdar.
President of the petitioner is present. Mr.
T. Hussain, Lordship.
T. Hussain.
Yes, Lord.
Learned counsel has submitted that he has instruction. You have already filed Ukalanama.
No, Lordship.
He has instruction to appear on behalf of the respondent number 8 and 9, and he'll be filing the Ukalannamas on their behalf within a week from today. First up. The other respondents are represented by Mr. S. Dottal, and Standing Counsel, Panchayat and Rural Development Department, and Mr. S. Roy, Junior Government Advocate.
3 and 4.
Others are represented perhaps?
Yes,
Represent.
yes.
So these are two, okay.
Service complete.
As all the respondents are represented, list the case on students in the admission column.
First Zoom. Few weeks.
In the admission column, meanwhile, the respondents may shall file their counter affidavits. File your counter affidavit also.
1206.
Any interim order?
Lower.
Item 38.
May it please your Lordship. I am appearing for the private respondent number 4. Matter is regarding demarcation, but our land and their land is separate.
No, we are not into that.
Yes.
At 5 o'clock today.
Yes.
You have been served.
Yes. So I'll.
And so all respondents are represented. Let it be on admission on.
Yes, last time there is an order, but our land is already demarcated, Lordship, in 2000.
No, I am not
No,
applying my mind.
Understood.
That is all.
3 weeks time to file affidavit.
I heard Mr. P. A. Ahmed, petitioner, revenue, aforesaid, H.K. Hazarika, 2 and 3. Mr. J. Dekar, learned counsel, has submitted that he has entered appearance. He has instruction to appear on behalf of the respondent number 4. And the Ukalanama will be filed within.
Already filed.
And Ukalanama to that effect has already been filed. He has further sought for 3 weeks' time to file a counter affidavit on behalf of the respondent number 4. The prayer is out. Release the case on Swain.
1506.
Obliged, Lordship.
Item 49.
Thank you. Right, please, your Lordship. Lordship, 2 bank accounts, Lordship, both have been frozen.
Tell me what to do today. Not applying my mind.
Tomorrow, Lordship.
Without applying, no, tomorrow is not possible.
Tomorrow, Lordship. Only problem, Lordship.
Let it be. No, Mr. Kapil.
My Lord, I am paying for the.
Don't overburden the registry also at 5 o'clock.
No, I don't want to argue, Lordship. I'm just saying that can it be taken up day after
No,
tomorrow?
not possible. This week we can try.
My Lord, I am paying for the bank, my Lord. Reason I have filed that reply also in this case, my Lord. So let them file their reply in my.
No, if they do not want to file, why?
Then
I am for the
Is the
bank, my lord.
couple
Cyber-
petitioner and Mr.
K Das, your lord. So
K Das for the respond number
456, my lord.
456 are present. List the case on Friday.
My lord.
Fine. Hello, please.
Item 50.
Yes, sir.
Service is completed, I think.
Service is complete. Yes, B.K. Sharma, Learned Counsel for the petition is present.
I am for respondent number 2.
Mr. Sharma, M. Sharma.
Yes.
You appear for whom?
Respondent number 2, ICICI Bank.
Respond number 2.
Your lordship.
Mr. S. Roy, SS Roy, CGC 3.
Your lordship, I am from respondent number 1,
1. Miss?
B Thakuria on behalf of P Hajorika.
Okay, respond number 1.
Your lordship.
Who is for 4? Mr. Roy? Some Cyber Crime Coordination Center. Okay, it is by registered post 4. And 5 DGP. Okay, 5. HK Hazarika. 5 and 6. In view of the office note dated 13/5/2025. Hey, all Loajima court thereafter release the case on sales. I do not ascertain service as regard postal Loajima court. Thereafter release the case on sales.
86.
Okay. That's one of 4 huh?